Thank you, Randall. So my name is Roger Daniels, and Chair, MC for this evening. We'll be so this evening we'll be starting with our comments from the chief. Then we'll go to a ratification officer, Joyce Woolheather, and then the TLE settlement agreement with David Noel. And after Joyce and David speak, if you have any questions, then please ask any questions then. And then we'll do, Stephen Pillipal will be doing the legacy trust agreement, and Louis Tapper will be doing the financial advisement. Those two presentations we'll treat as one, so question and answer period will be after they're completed. Okay, so Chief.
I guess I hope you don't mind, I'll take my mask off. First of all, I'd like to acknowledge Creator for this beautiful day that he rendered on our behalf. I'd like to thank Mrs. Mistawasis for rendering a prayer for the community and for the meeting this afternoon. And also I'd like to recognize, the drum that was played for us today. The drum, as you all realize, as you all know, is the heartbeat of our nations, our people. We still hold our traditions and values close to our heart here in Mistawasis. As we begin, this process today of trying to put some clarity onto what's been transpiring over the past number of months in our communities, we've come to the understanding that social media has really took an awkward course, I guess, with respect to identifying the true nature of what we're trying to do here with the TLE and the specific claim trust. So as a result, a lot of negativity through Facebook, a lot of uncertainty that has clouded the minds of our people to the point where uncertainty is going to lead to a no vote. So hopefully, with the understanding that that we're going to present today with our legal people, the financial person Louis Tapper, and the lawyers, Stephen Pillipal will speak to the legacy trust. The Robert, Mr. Nault here. Kind of a little late today, but nice to see him here as well too. So as we begin this process, I'd like to welcome everybody to this informational setting, and hopefully we can try our best to answer as much of the questions that you may have uncertainty-wise. Please don't hesitate to ask any question. If it's minor in nature, if it just needs clarity, please by all means just ask as many questions as you like. Hopefully we can address and put things into perspective for you as we move forward. Over the past, number of years, we've embarked on a journey that looks at trying to remedy and correct all the land wrongs that happened in Mistawasis over the number of years that we've been around as nations, and that's not a very long time. We're looking at about 140 some odd years since we tried and signed treaty. In 1876, when Chief Mistawasis made it, his vision and plan to go get involved in treaty number 6 in 1876, he saw that the lifestyles of our people were changing drastically. The newcomers were adding challenges, bringing disease and sickness to our people. The buffalo were being decimated. A whole new life had to be explored. So with the vision of Chief Mistawasis, he began the process of bringing people together to try and understand, the benefits of treaty. With that, this is where we are today, 140 some odd years later, with the support of Chief Mistawasis and the people that collectively came together to understand treaty. Back in 1887, we often refer to that date as the date of first survey, when the First Nation was basically measured, or I want to say came about, I guess, with the square mileage. It was based on a population. When the date of first survey first happened in 1878, each one of Mistawasis's band members at the time were counted. But for some apparent reason, some of our people were off hunting, they're out gathering, maybe they were off in another First Nation community or doing whatever they felt was appropriate, so they weren't counted in. So as a result, this is where we are today with the tree land entitlement that is being proposed to you for your consideration. Our tree land entitlement as a result of our shortfall acres. When I mentioned some of our people weren't counted in, as a result, we've identified X amount of people, and David can probably give more clarity to that. I'm just giving a general overview of Data First Survey and how we came about with TLE. So as we begin the process of understanding what TLE was all about, it came through in the early part of 1994 or 92, I want to say, when there was 25 or 26 First Nations across this province that had serious reservations about how their reserve was came to be about, I guess. They felt that they were shortchanged. They should have been given more land than they were entitled to. So as a result, they lobbied the government. And as a result of that, a framework was created, a Treaty Land Entitlement Framework back in 1995, I think. I'm not sure, but again, date's 92. So as a result of that, a process was identified. So as First Nations began to understand that they were shortchanged, their due diligence began. Research was done to identify how many people may have been miscounted or counted in other First Nations. So as a result of that, we have a claim today where our shortfall acres is 4,235 acres, I think, or 53 acres. Those numbers are always, it's about 4,352 acres of what we refer to as shortfall acres. And those are the acres that should have been put into place when Data First Survey happened. Our reserve was measured at about 49,000 acres. But when we realized that we were shortchanged, the amount of acres that we were entitled to was 53,000 plus. So as a result, our shortfall acres was at 43,000 acres. So as a result of the framework agreement, there was a formula that was created that basically looked at your equity acres in the sense of using numbers to bring our number up to a certain amount. So throughout the years, Mistawasis has been involved in trying to move this TLE file forward since 2001. So 20 years later, we're at the point now where we feel we have an offer that is something that should be taken seriously by the membership, because it has a lot of advantages, and those advantages can speak for themselves with respect to identifying, all the resources that we could be saving if we look at amalgamating both the specific claim and a TLE trust. But amalgamation is something that we're asking you to do, but doing it through an amendment process through the specific claim process. So as a result of that, this is where we are today. We have an offer from Canada that speaks to, X amount of dollars for the benefit of the nation. So as we begin, the process, there's a lot of information that needs to be put into perspective. And as a result of that, we have, two lawyers here today that have a multitude of years of experience dealing with outstanding land claims, TLE, whatever. And Mr. Louis Tapper is the financial advisor that will walk us through the process of how the financial picture would look, if we looked at amending the trust agreement and moving forward with that. So if any questions, please don't hesitate to ask as many questions as you can. We're here to try and support the process and try and make everybody informed in a good way, so we can make that decision whether to support this process or not. And that decision is entirely up to the individual here in our community. So please don't feel that you're pressured in any way to vote yes. Please don't feel that you're pressured in any way to vote no. That decision rests with you and you alone. Like I mentioned, we got to start coming together as a community. We're almost 3,000 band members strong. The vision and the hopes that I want to see for our community is that our young people will have a solid future. And a lot of us now, we're up in age. We're 60 plus years old, some of us. So in saying that, we don't have much years, Some of us might be granted one more day, 2, a month, 3, 4, 5, 6 years, 10 years. But at the end of the day, when we're all long gone, it's going to be our kids that are going to be here taking on the responsibilities of what we're starting here today. So think seriously about, not only today, think about, the community that Mistawasis where he wants to be in 20 years' time. And this isn't only the claim that we're pursuing on your behalf. We have a number of outstanding claims that we're currently pursuing. Just to maybe just put things in perspective, with the specific claim in 2001 that we ratified, now with the TLE in 2021. We have also a certificate of possession claim that's in the system as well. We have a mismanagement claim as well, and which the big claim which everybody is always inquiring about is our cows and plows. Cows and plows is still in the research stages of development, so we have a long ways to go. And it's been very challenging with COVID, trying to get into certain departments to research and understand, the process. But again, all those things are in the works on your behalf. But today we're here to speak specifically about the TLE and the amendment process to the specific claim trust agreement. So have a coffee, ask as many questions as you like, and we'll be here hopefully till 8 o'clock. So thank you all for coming and attending.
Thank you, Chief. Next on the agenda is Ratification Officer Joyce Woolheather. Joyce.
Good afternoon, everybody. Can you hear me all right? So I would like to thank the elder for the prayer, the chief, and the drum. Okay? I think so. Okay. So I have been appointed as your ratification officer for this Treaty Land Entitlement Settlement Agreement vote. And my role is to conduct the vote as set out in the Settlement Agreement Voting Guidelines and Procedures, which were included in your information package. I will briefly go over the voting process and how to fill in the mail-in ballot package. So members of the Mistawasis band who are 18 years of age or older as of November the 10th, 2021, the day of the vote, are eligible to vote on this settlement agreement. The notice of vote and the voters list were posted on reserve at the band office, the health clinic, and the IBC training center. If you find that a voter has been omitted from the list, incorrectly listed, or that a person not qualified to vote has been included in the voters list, you can advise the membership clerk or myself, and we will follow up on amending the voters list if required. There are two methods of voting. You may vote in person at the poll on the day of the vote, or you may vote by mail-in ballot, but you can only vote once. The poll will be held in the Chief Mistawasis School Gym on November the 10th, 2021, from 9 in the morning until 8 p.m. Information packages, along with the mail-in ballot package, have been mailed to all voters whose addresses were provided. If you wish to vote using a mail-in ballot, you can mail the ballot to the Regina office, Prince Albert office, or you can hand deliver it to me or one of the deputy ratification officers. The deputy ratification officers are Debbie Watson, Tony Black, Roger Daniels, Daryl Watson, Robin Daniels, Colby Daniels, Stephen Johnson, Derek Sanderson, Leslie Pachuis, Anita Johnstone, Louis Ledoux, and Lawrence Johnston. To complete the ballot, you will put a X or a check mark or some kind of mark in either the yes or no box without identifying yourself. You'll put it into the mail-in ballot envelope with the declaration on the front. The declaration has to be completed with your name and date of birth, your status number if you know it, and your signature. Your signature needs to be witnessed by somebody who's 18 years of age or older. This information has to be filled out for us to be able to count the ballot the night of the vote. If we receive this and all the information hasn't been filled out, we will try to contact you so that we can get the information from you. So all ballots must be received by myself no later than the close of the poll, 8 p.m. on November the 10th. Any ballots received after that time will not be counted. The vote is conducted by secret ballot, and you cannot vote by proxy, which means someone else cannot vote for you. If a voter receives a ballot that is improperly printed, stained, or a voter mismarks the ballot, the voter can request a new ballot from the Ratification officer, the original ballot will be marked void and will not be counted. So myself or one of the deputy ratification officers can assist a voter in marking the ballot if requested to do so. The ballots will be counted after the poll closes. The count can be viewed by any member of the First Nation and will be held in the Chief Mistawasis School gym. COVID measures will be in place. I will open the ballot box, inspect the ballots, and each ballot, other than those rejected or voided, will be shown to those in attendance. Voided ballots are not opened or counted, and rejected ballots cannot be shown as the voter may be identified. A ballot will be considered rejected if the intent of the voter is not clear, so you've marked both the yes and no box, or you have identified yourself, either with initials or wrote your name on the ballot. Excuse me. A number of individuals will have tally sheets to ensure the count is accurate. A large tally sheet will be placed on the wall so that everybody in attendance can see how the count is proceeding. To consider this a yes vote, 50% plus 1 of all eligible voters that appear on the voters list must vote yes. There are approximately 2,100 names on the voters list, so 1,051 voters must vote yes in order for this vote to be successful. The total number of eligible voters may change if the voters list is updated. For the review procedure, a voter can request a review of the vote by the minister if you believe that there was a contravention of the voting guidelines that may affect the results of the vote, or there was a corrupt practice in connection with the vote. A request for a review of the vote shall be made by forwarding the request to the minister by registered mail, addressed to the Assistant Deputy Minister within 7 days after the voting day, accompanied by a declaration containing the grounds for requesting the review and any other relevant information, and be signed in the presence of a witness who is at least 18 years of age. We will be accepting ballots tonight in the completed declaration envelope. So if you would like to vote today and you don't have your ballot, we do have extra ballots. If you require assistance, one of the deputy ratification officers will be able to help you. Are there any questions? Yes? I keep track of all the mail-in ballots that I've received, and I will be bringing them with me on day of vote. So if they decide they want to vote in person on the day of vote, we will grab that envelope that I have, and I will ask you if that's you, and if you say yes, then you have the option of saying, no, I don't want the vote in that ballot envelope. I want to vote today. And the other one will be marked void because you can only vote once. You're welcome. Was there another question?
Just so people know, if they do have questions, if you could come up to the microphone, it'd be appreciated, because both microphones are being fed into the YouTube stream, so that way people following online will know what question was asked. Thank you very much.
I think arrangements may have been made to deliver those. So as we get closer to vote date, I also encourage people not to put their package in the mail, but to try to hand deliver it if possible, either to the Prince Albert office, Regina office, or one of the deputies. If you do want to mail that, you should be mailing it back soon. Okay? Okay, thank you.
Thank you, Joyce. And Anita did bring up a good point for anybody that gets some mail in Leask. There are a large number of packages at the post office, and they only keep them for so long. The packages are too big to fit into the post office boxes, so there will be a notice in your mailbox. So if you can, yes, please go to the post office and get your information package. Any other questions for Joyce? Okay, so I will knock this over. While I'm getting David's presentation up and running.
Just for the sake of people that are living in the city also that may live in apartment buildings, again, they do have little boxes. So again, for those that are listening, that are in cities that live in apartment blocks, please go and check and pick up your parcels at the post office to get your mail in the post office, because that's very important that you do that. Thank you.
Thank you, Stephen. And just before David starts, we're change it up a bit on the presentation on YouTube, where the James, our tech guy here, will be following along the PowerPoint that will be used. It'll be online, so it'll be easier for everyone to follow. Instead of we had issues last night with the glare from the screen. So, David, all yours.
Okay, good evening. My name's David Knoll. I've been legal counsel and I've been working with the First Nation since 2002 on this particular claim. I've also worked in Saskatchewan on probably about 26 other entitlement First Nations in the ratification of their agreements as well over the years. You should, I encourage you to pick up the package, because in that package, if you don't already have it, there's a summary of the settlement agreement, an executive summary of the settlement agreement, as well as a more detailed summary of it. And today I'm going to be going through a PowerPoint presentation. So what you should have in the package is a copy of the settlement agreement, an executive summary of the settlement agreement, a more detailed summary of the settlement agreement, and then I'm speaking to you through a PowerPoint presentation. So I'd like to start by giving a bit of a background to how this all happened. Back in the 1970s, one of the First Nations in Saskatchewan figured that they never received all the land that they should have under their treaty when the surveyors were out there and surveying the reserve for them. They thought they were shortchanged. They should have received more because some of the members were not counted that should have been counted. So they went to the FSIN and they said to the FSIN, can you check into this? So FSIN retained some researchers out of Ottawa. Tyler and Wright was their name, and they went and they conducted research. They actually looked at all the First Nations in Saskatchewan to check, whether all of them received the land that they were entitled to, who were shortchanged or whatever. They prepared a report and gave it to the FSIN, and the FSIN looked at it, and there were actually 26, I think, First Nations that didn't receive. They identified 26 First Nations. that didn't receive the land that they were entitled to, either under Treaty 4, 6, 8, and 10. So then FSIN said, well, what are we going to do? So they went to Canada and they said, hey, Canada, you have an obligation under the treaty to provide the land that you should have provided to them to begin with. There's a shortfall. These 26 bands never got all the land that they should have received. Canada said, well, we have to go to the province because of the Natural Resources Transfer Agreement. They have a duty to provide us with the land, and then we can transfer it over to reserve status. The province then had a problem with that because they said, before we transfer this land to you, we want all these third-party issues dealt with first. We're going to give you clean land without all these third-party issues. We don't want any mortgages. How do you deal with roads? What about water? All this sort of stuff. So Canada said, well, you know, if that's the case, how are we going to resolve all these third-party issues? And this dragged on for 5 or 10 years, resulting in a court action that took place in 1976. Well, actually, it took place a little bit later. But they said in the court action, there was a previous formula for settling this called the 76 formula, where they calculated how much land they should have received and how many people should have been counted, and then they just added 128 acres to that new population figure. But the province wasn't very happy with the 76 formula, and that was the resulted in a court action. After the court action had been working its way through the courts for about 5 or 10 years, Canada said, look, we don't want this to end up in court and have a long, drawn-out court action. Let's see if we can resolve this through some sort of negotiation. So they set up what an Indian Claims Commission that was set up in the 80s. They conducted a survey, and they ended up determining yet a new formula, which was called the equity formula. So under the equity formula, they approached the FSIN and said, look, are you prepared to settle? Are the entitlement chiefs, there was an assembly of entitlement chiefs, are they prepared to settle under this new equity formula? It took a while for the entitlement chiefs to look at this, because under that formula, it was a different approach to settling this treaty land entitlement obligation. Under the Natural Resources Transfer Agreement and under the treaty, Canada was obligated to transfer land to fulfill that treaty land entitlement obligation. This equity formula was a little bit different. It said they would provide the First Nation with enough money for them to go out and get the land and deal with all these third-party issues. And then once the third-party issues were dealt with, Canada would then transfer to reserve status, working with the province to do that. So the 26 First Nations said, okay, if the province and Canada can't solve this issue between themselves, we'll do this under this new formula. So in 1992, there was a settlement involving the 26 First Nations called the 1992 Saskatchewan Treaty Land Entitlement Framework Agreement. Under that agreement, and I'll bring this up here, under that agreement, the 26 entitlement bands were paid approximately $500 million. This was shared between Canada and Saskatchewan on a 70-30 basis. And the payments were made out to those First Nations over a 12-year period, and that permitted them to acquire up to 1.67 million acres of land in Saskatchewan. It was this framework agreement that the First Nations then went out, and many of them have been using these monies to acquire and satisfy their treaty land entitlements. And it also formed the basis for about 5 to 8 other First Nations in Saskatchewan that looked at this equity formula And they said, hey, if we apply that equity formula to our situation, we also didn't get all the land that we were entitled to. So there were those other TLE bands after 1992 that used this formula to settle their claims. And their payment was out over a 5-year period. They were able to negotiate the payments over a 5-year period instead of a 12-year period. So in 2005, the Mistawasis First Nation submitted a claim to Canada and said, look, using this equity formula, we also didn't receive all the land that we were entitled to. They looked at the 1878 reserve and the survey. 49,280 acres were surveyed, and they said actually it should have been 53,632, and we were actually shortchanged 4,352 acres. Canada, you have an obligation to provide us with 352 acres of land. So they went back to Canada, and Canada eventually agreed that this was correct. They were Mistawasis First Nation. The First Nation was shortchanged. They should have received some more land, and the shortfall was 4,362 acres of land. So in March of 2019, Canada made a global settlement offer in the amount of $31,576,975,000. That included $1,222,709 to cover land acquisition costs, ratification costs, negotiation costs, and some miscellaneous costs as well. Saskatchewan's portion, remember, the deal under this framework agreement was a 70-30 arrangement. So Saskatchewan's portion of the settlement is $9,106,280, and Canada's proportion is $22,470,695. The First Nation, and once that global settlement offer was made, they passed a BCR accepting that basis on which to settle their TLE claim under the principles of the 1992 TLE Framework Agreement. This is a sort of a summary of what I've already covered. The shortfall acres, 4,352 acres. I just want to spend a little time on this shortfall acres. Canada says, this is what we legally owe you. You were shortchanged at the time of treaty when the reserve was first surveyed. You should have received 4,352 acres. So the money that's going to be placed into the trust account, the first obligation under the TLE settlement agreement is to acquire these shortfall acres. And that includes not just the surface, it includes the subsurface, the minerals underneath, as well as dealing with all these third-party issues. Once that shortfall acres is acquired with reserve status, then if there's any money left over in the trust account, you can use that money to acquire up to an additional 29,394.18 acres. That's the total amount that you can acquire with reserve status. And you don't have to get the subsurface minerals necessarily. Or you can use whatever's left over in the trust account for band development as well. So the key purpose of this settlement agreement, the TLE settlement agreement, is to first of all get those shortfall acres. If anything's left in the trust account, you can use it for band development or acquire more land up to those equity acres. There's a breakdown of the various costs that Canada is prepared to pay. $30,158,425,000. That's the equity payment. Mineral payment, an additional $195,000 plus. Land acquisition costs, negotiation, ratification, and additional costs. Those are all outlined there. Canada will make its payments first into the legacy trust account, which Stephen will talk about a little bit later. within 45 days that Canada finally settles this. And it's called the execution date, the settlement agreement. So after you ratify this agreement, it goes to the province then signs the agreement, then it goes to Canada, and Canada has to finalize it from their side. So within 45 days of the execution date, Canada's portion, that 70%, will go into the legacy trust. Saskatchewan, on the effective date, transfer their portion of the contribution to Canada within 45 days, and then Canada has to transfer it into the legacy trust, your trust, within 45 days. If you received a package, you'll also see with the settlement agreement a bunch of schedules. So the Schedule 1 deals with the mineral revenues. This identifies all the minerals that you might have to deal with when you go out to acquire your shortfall acres. It lists all the minerals under the ground that you might, if anybody owns the minerals or have an interest in the minerals, if they lease the minerals, or they have permits to use the minerals. This outlines the type of minerals that have to be dealt with. If the minerals are undisposed of, in other words, there's no leases, no one owns the minerals, they're called undisposed of minerals, and you get those for free. And Stephen will probably talk to you a little bit about that later. Schedule 2 deals with the amendment between Canada and Saskatchewan to the Natural Resources Transfer Agreement, because what's happening here, the province isn't transferring land to Canada for a reserve, they're transferring some money to Canada to enable you to acquire this land. So the Natural Resources Transfer Agreement had to be amended. It's an agreement between Canada and Saskatchewan. Schedule 3 is the ratification vote guidelines, and Joyce has covered some of that, and I'll touch on that a little bit later. There's a certificate of independent legal advice. I have to sign this certificate informing Canada that I attended this meeting and all the other banned information meetings, that I answered questions, I explained the settlement agreement, and I provided you with some material that covers the details of the settlement agreement. Schedule 5 is a certificate of independent financial advice, and Louis will be talking about the financial side of things, and he has to sign that certificate. Stephen also has to sign a certificate dealing with the trust side of things, which he will be talking about. There's terms and conditions of entitlement reserve creation. This lists all the steps that have to be followed once you purchase the land, say from a farmer. How do you get it to reserve status? How do you work through the Department of Indian Affairs? And how do you deal with the province? So I'll cover that a little bit later, but it's a step-by-step process that you have to follow. There's also an appendix called the Public Utility Agreements. You might have some land that you're looking at which has SaskTel or SaskPower or some transmission lines through it. These are the type of easement agreements that have to be entered into with those public utilities. So this is, again, a bit of a summary of what I've already covered. The money that's placed into the trust account is, first of all, to be used to acquire those shortfall acres, 4,352. There's also a provision in the settlement agreement that tries to ensure that that $30 million plus that are going to the trust account are not subject to tax. It doesn't affect the settlement of this agreement, doesn't affect any other program funding that the First Nation receives, and it doesn't prejudice the right of the First Nation to determine its own membership. And if in the future there's any constitutional amendment that you can benefit from, that benefits you, this agreement can be amended to take advantage of those benefits. Okay, so now you're looking at some land, and you want to buy from a farmer some land. So whoever's responsible through the trust agreement or whoever's the land acquisition person goes to the farmer and you negotiate with the farmer to acquire that land on what's called a willing seller, willing buyer basis. So you try and negotiate a settlement with the farmer. Now there is an upper limit on how much money can be spent before you get the shortfall, before you get the shortfall acres. So there is an upper limit to ensure that Canada can be satisfied the shortfall acres have been acquired. In other words, that money in the trust account can't be used perhaps to go to Saskatoon and acquire an acre of land and pay and use up all your money to get that acre of land in Saskatoon, and then you don't fulfill that shortfall acres. So most of the First Nations have gone into the rural areas and other places where they can satisfy that shortfall amount first because of that upper limit requirement. Canada just doesn't want all the money spent on a few acres. You've got to get that 4,000 plus acres first with those shortfall acres. All the land has to be acquired in Saskatchewan. You can't go to Manitoba or Alberta to acquire the land for TLE. Now, once you go to the farmer and the farmer says, you negotiate a deal with the farmer to purchase the land, then you have to determine whoever's handling the purchase of the land and getting it into reserve status has to check the title to make sure all these third-party issues are dealt with and identifies what needs to be dealt with. They pass a band council resolution indicating that they want to purchase this land and have it transferred to reserve status. That goes to the department. The department registers that band council resolution, and they notify the province that this First Nation, Mistawasis, wants to acquire the land with reserve status. Once the band council resolution is registered, someone from the department is assigned to assist the First Nation in preparing a formal submission to have this land acquired, all these third-party issues dealt with, and then transfer that to reserve status. Once the submission is complete and the person from the department, the First Nation, thinks that everything's ready to go, they submit it to what's called the Additions to Reserve Committee. They have a certain amount of time to make a decision whether to transfer it to reserve status and accept it or approve it conditionally. And so they can either say yes, or they can say, well, maybe there's certain things that still have to be completed before we will approve it for reserve status, or they may actually look at it and say, no, we're not going to accept it. But if they make a decision not to accept the land for reserve status, they have to provide a written explanation and give you reasons why they rejected that submission. I haven't heard of any that have been rejected. Maybe Joyce knows about it, but I think most instances, by the time they go through this whole additions to reserve process and prepare the submissions, in most cases, they've gone through and been approved for reserve status. Okay, you've got some land that you're interested in. The farmer has some land. You look underneath and, oh, there's some minerals there. Okay, now you've got to deal with these minerals. And the shortfall acres have to be acquired, remember, with the minerals. So there are certain people that either own the minerals or have an interest in the minerals, and you have to negotiate with them. There are arrangements with Canada to assist you in getting those minerals, because Canada has an interest also in getting those shortfall acres as quick as possible. So you might be able to work something out with them to get the minerals. But sometimes the biggest delays are in getting the minerals. Most of the minerals in the south, many of the minerals, I should say, if not most, in the southern part of Saskatchewan have been disposed of. In other words, some companies own them, either the provincial or the federal crown. Someone owns these minerals underneath. And it's much more difficult to try and negotiate the acquisition of these minerals. If you go further north, northern part of Saskatchewan, it might not be all that bad. Now, Stephen will probably be talking about the undisposed minerals and those type of issues later, but just to make it clear that the shortfall acres have to have the minerals, and if they're undisposed of, you get them for free. Now, the farmer that you're looking at, you negotiated to purchase the land, he may have some water on his land, and it may be either wholly enclosed, or there may be a creek or something that flows through the land, or is adjacent to that parcel of land that you're looking at. Well, then you've got to deal with the water. If the lake or the pond is totally within the parcel of land you're looking at, you can get the lake, the water, the beds, the shores, everything. If, however, there's a creek that flows through, or a river that's adjacent to it or next to it, the land that you're looking at to purchase, then you can acquire what they call the high water mark of it, ordinary high water mark of the shore of that water body. You can purchase that, but the most important thing is that you can make sure that the quality, quantity, and flow of that water is not disturbed. If there's a project upstream or a project downstream that pollutes the water, you have a right to seek some sort of compensation from them. And if in fact there's going to be some sort of project that might be put in place somewhere upstream or downstream that you anticipate may have an adverse effect on the water, there are provisions in here that you can participate in the decisions with respect to that project itself. But I haven't heard of any instances where any First Nation who has a TLE claim has participated in determining a water project that has an effect on the water that flows through the land that you're interested in. So the farmer land may have a road. If it's a provincial highway, normally the provincial highway will not be transferred over to the First Nation at all. There is an ability to reach an arrangement with Canada on undeveloped roads, gravel roads or something. You can probably acquire those on the understanding that if in the future date the province wants that road for a public purpose, then you have to provide that road back to the province. But if you've built any improvements on it, say it happened years ago, you acquired the road and you built a house or something on that area where the road was, and the province says, we want that road back, then they have to arrange some sort of compensation for that improvement that you made to that area. There is a cost-sharing agreement in rural municipalities, in the rural areas, if you're looking at purchasing some land in the rural areas. And it's a cost-sharing agreement. A certain amount, 20 years of money is put into this pot by Canada and Saskatchewan. This is to compensate the RMs and the school divisions in rural RMs and school divisions for the fact that they will not be able to obtain any tax from the land once it becomes a reserve. So they will be getting some compensation out of this fund that Canada, it's not coming out of your money. Canada and Saskatchewan are setting aside a separate fund to compensate these rural municipalities for any reserve land that might be set up because they can't collect tax from it anymore. There might be some other third-party interest. You may go out and look at this farmer's land, and he may have a mortgage on the land. There may be a tax lien. There may be other sorts of issues with respect to the land that you have to resolve and have changed or reach some sort of an agreement to deal with these type of third-party issues. Now, Mistawasis has a land code, and under the provisions of that land code, there's a certain ability to deal with these third-party issues and resolve them. And if in fact, if in fact you are able to deal with it through the land code provision, that is okay, or through provisions of the Indian Act. The Indian Act has been amended to enable the resolution of these third-party issues as well. And you may, down the road, there's some third-party issues, you may look at it, the Indian Act approach to it and decide it's quicker, more efficient, and less costly to do it than actually terminating it through your own land code. But there is an option there now in the settlement agreement to use one or the other, either proceeding under the Indian Act or under your land code. Yep, there's a question.
You were talking about the money that the government Canada has for taxes. Is that above this money, or is there another pot?
It's a separate fund that's set aside between the province and Saskatchewan to compensate the RMs and the school divisions for the loss of taxes once you have a farmer's land transferred to reserve status, because they can't collect tax once it's a reserve. The RM can't anymore. So there's this separate fund. It's not over and you're not getting it. It's a separate fund that's set aside by Canada and Saskatchewan.
So that that doesn't show on what we're voting for now?
No. Well, the settlement agreement talks about that, but it's an agreement between Saskatchewan and once your agreement is in place, there will be some funds agreed to between Canada and Saskatchewan to deal with any lands that are acquired in rural municipalities.
And that's going to continue, that's going to go on and on, and
it's a 20-year fund that's set up.
For 20 years?
Yeah, a
Okay.
20-year fund. Yeah. It also, there's also a provision that even though the RM has these funds, that doesn't mean if there's a road across the land, the reserve land, that they don't have to maintain it. The fund is there to compensate them for lost taxes, but they still have to maintain the road as well. Shouldn't come out of your settlement monies to maintain any roads, provincial roads that go through your land. Now, as I mentioned, once you get the shortfall acres, most of the TLE bands that I'm familiar with then look at if there's any monies left over in the trust account. They look at some urban property. Now, in urban property, there's no separate fund to compensate urban municipalities for lost tax revenue or school divisions for lost tax. So you have to negotiate what they call a service agreement with the urban municipality, Saskatoon, PA, whatever, to deal with the type of compensation to compensate them for any taxes that are required. Compatible municipal and band bylaws have to be negotiated so that there's no inconsistency between your bylaw and the municipal bylaw. There's also enforcement mechanisms in there and dispute resolution provisions in those service agreements. So, as you're probably familiar with, some of their First Nations do have urban property, and it might be, if you're looking at purchasing some urban properties down the road, you might benefit from discussing how they went about doing it as well. There is a provision, if you spend several years trying to negotiate a service agreement with the municipality, and Canada and you come up with what you think is a reasonable, fair, and a settlement agreement or service agreement, and you didn't act in bad faith, but you think that the municipality has acted in bad faith, you might be able to persuade Canada to go ahead and set this land aside with reserve status, even though the municipality hasn't agreed with it. But the municipality has the option of saying, look, we didn't act in bad faith, we don't think we acted in bad faith, and they can go to Canada and try and demonstrate that they did not act in bad faith. And Canada, in those circumstances, wouldn't set aside the land with reserve status until that issue is resolved, that service agreement is resolved between the municipality and the band. Because this agreement is satisfying Canada's outstanding treaty land entitlement obligation and Saskatchewan's obligation under the Natural Resources Transfer Agreement, both of them want a full and final release of the treaty land entitlement obligation. It doesn't affect any other claims that you may have against Canada. This only is the treaty land entitlement obligation. So it's in full and final satisfaction of Canada's treaty land entitlement obligation and Saskatchewan's obligation under the Natural Resources Transfer Agreement. So if the population from this First Nation increases down the road 15 years from now, you can't come back to Canada and say, oh, our population has grown and we're entitled to more land. This is in full and final satisfaction of the treaty land entitlement obligation, not any other specific claims. This does not, as I mentioned, doesn't affect any other claims you have or any of your treaty rights. And if, in fact, and I've never seen this happen, but if your treaty is amendment and there's some benefit to you through an amendment to your treaty, well, then this agreement can also be amended to take advantage of that variation in the treaty. There are settlement boards. There is a provision in the agreement for settlement board and arbitration, but there are very few. I don't recollect any First Nation that has gone through these provisions. But if you ever involved in a dispute of some sort involving treaty land entitlement, you can go to the settlement board or you can go to arbitration to have those issues resolved. As I mentioned before, on the tax side of things, there is this fund set aside for RM and school division tax provisions to compensate them for loss of tax on a 70-30 basis. There's also the funds, the 30 million some dollars that are placed into the trust account. That's the capital amount that's placed into the trust account is non-taxable. There's also a GST remission order. You don't have to pay GST on the purchase of TLE land, minerals, or improvements, and you don't have to pay GST on any of the acquisition costs when you're going out there to purchase treaty land entitlement land, minerals, or improvements. Now, there's public utility easements that I talked about earlier. There's no fees that can be charged against SaskTel or SAS. There is an easement that goes through there, but no additional fees can be charged to those utility companies. Joyce has gone through this ratification process in some detail already. I don't think I need to spend much time on it. The important thing to note is that 50% plus one majority members have to vote to approve this. Otherwise, it will be a no vote, and everything's off the table. There are provisions for a second vote if there is a no vote, but that would take some time because then you have to go back and figure out, well, why was there a no vote this time? Was it because not enough people voted, or because they voted because they didn't like something? What is the reason? And then you go back to Canada and Saskatchewan and come up with whatever revisions, either to the settlement agreement or the trust agreement, and then come back for a second vote. But if you fail the second time, I guess that's it. So hopefully you'll get through. I anticipate you'll get through the first time, but you have the option of a second vote. So that's my presentation. Are there? Yeah. Well, I'm open for questions now. You can have 3 more questions.
Okay, like on that ballot that's sent out, there's 3 parts to it. like we have to say yes to, there's 3 parts to it.
Yes.
And that is the confusing part to me. I was on council and I look at this and say, what the hell? I thought we're voting on just this, accepting 31 million. But we're not. We're also we're saying yes to putting these two, getting rid of our specific land claim and putting them together with that. That's the confusing part.
Okay. Well, on the trust side, I'll leave that to Steve and Louis to speak to, but I just want to make it clear that all TLE bands that have settled their claims in Saskatchewan have voted for the settlement, approving the settlement agreement and a trust agreement. So there's been no claim, that TLE claim, where you just vote on the settlement agreement. It's a vote for both, the settlement agreement and the trust agreement. Now, Steve and Louis will talk about the trust agreement and the wording in your ballot about the trust agreement, but the settlement agreement is all I'm speaking to. So the ballot question, if it's confusing because of the trust provisions, Stephen and Louis will speak to that.
So I just want to clarify something there about Canada and Saskatchewan. They're getting off the hook just in case there's any more land entitlements coming up.
Yeah, this is in full and final satisfaction of the treaty land entitlement. Now, there may be a surrender claim or some other claim where you claim that the land was wrongfully taken through a wrongful surrender or something. I think you already have something like that. That isn't a treaty land entitlement. That's a separate specific claim, and you can still pursue that. But you can't come back to Canada and claim under the treaty you were shortchanged for more land and more. Since the population grew 5, 10, 15 years, you're entitled to more land. This is a full and final satisfaction of that treaty land entitlement obligation. I'm game for more questions here. You have another one? Yeah. So I wish you all the best, on the vote. This is a pretty big deal. It's been 20 years in the works. We've finally come to the stage where there's a vote for settling this treaty land entitlement obligation. And I encourage you to read the documents, try to understand that, and then vote.
Let's see, how can I work this? David, I just want you, I'm aware you can't speak about the trust and whatnot. I do want you to help me make it clear to the members that your role is in regards to the settlement agreement portion. And you have no involvement with the trust agreement side. And so Canada has no interest in our trust agreement, correct?
Well, Canada wants to make sure, it's not like Canada has no interest in the trust. There's certain provisions in the trust dealing with using the money to get the shortfall acres and that sort of stuff. So there's certain commitments under the settlement agreement that the trust has to comply with those. And Stephen will talk about those.
But they do not advise on the trust agreements.
No, they're not advising on the trust agreement.
And they don't want to see our trust agreements.
They don't what?
They really don't want to see our trust agreements.
I don't think they've seen the trust agreement, unless it's been mailed through the packages and they've had a look at it. But they don't comment on it.
Right. And according to TLE framework agreements, we can actually go to a negotiation with Canada to actually do a per capita share distribution.
Well,
out of the actual settlement.
Well, Stephen and Louis will speak to that. In the settlement agreement, there was a section where a certain amount of money could be used for what they call band development.
Right.
And I don't think that clause is in this agreement. It is still there. Okay. So that clause, and Steve will talk to that.
Yeah, for sure.
But a limited amount of money that can be used before you get your shortfall acquisition date.
Yeah, for sure. Like there's a certain value that can be provided, but that value could be increased if negotiated.
Yeah, I think it started off at 300 or 1,000 or 350. You know, and some First Nations have negotiated and increased by, you know, up to 1.2. I'm not sure. You know, it varies from different TLE First Nations have negotiated different amounts. Yeah.
Great, thank you, David.
Okay. Any more? Okay, thank you. I'm here, by the way, for the rest of the evening if there's any other questions.
All right, thank you, David. So next up on the agenda will be Stephen Pilipow with the Legacy Trust Agreement.
Okay, evening everyone. I'm Stephen Pilipow. I'm a lawyer, and I was retained by the First Nation to assist with the trust agreement that needed to be developed for receiving the funds. I just want to clarify a few things before I get into it. David had talked about that information package, and some of you have got it, some haven't, but David talked about the things that were in that package, but there's also a copy of the amended and reinstated trust agreement. It's the amended agreement, and we'll talk about that. It's going to become known as the Mistawasis Legacy Trust. There's also an overview and summary of the agreement that Louis and I have prepared together. And Louis there's also a paper that Louis prepared on the financial advice, which he's going to go through with you later today as well. So I know the chief had mentioned, and I know there's been some discussion, and they've talked to me about this whole thing about what is being proposed with the trust agreement, and you know, termination and merger and all this stuff. Okay, so I know at one time when we started out talking about the trust agreement. We sat down, you know, the chief and council, the trustees, and the other representatives of the First Nation that were involved in the negotiations. We started talking about this trust agreement, and I'm going to go through it in more detail a little later on. But we talked about you could have had two trust agreements, and when we looked at it, we said it would be better to have one trust agreement, okay? And I'll go through that with you. And it became pretty obvious when we went through it that it was in your best interest and the First Nations' best interest to have one trust agreement as opposed to two trust agreements, and I'll explain that as we go through. Now, we're not terminating the specific claim trust. So you may have heard that. That's not what's happening. We are amending the specific claim trust agreement so that it'll still be the specific claim trust agreement, but there's a lot of changes that are being proposed. Some of those are to meet the requirements of the TLE settlement agreement, and some of those are just being proposed changes to update the agreement, to change it in certain ways, and we'll go through that so that you understand what those are. Now, the current trust agreement, the specific claim trust agreement, does allow, we can't terminate it. It's quite clear. We've had legal opinions done that tell us we cannot terminate it. Okay, so the only thing we can do is amend it, and that's allowed under section 21.03 of the specific claim. It talks about the ability to amend the agreement, and that's with the member approval. So it can't change without the members voting in a ratification vote to approve the amendments. If you don't vote to approve the amendments, then this whole thing comes to an end. There was the question about the ballot, and there are three questions. One is, do you approve of the settlement agreement? The second one is, do you approve of the amendments to the specific claim trust agreement? And number three is, do you authorize the chief and council to sign all the documents necessary to implement the agreement and the amendments? So it's all together, okay? It's not, you can't vote yes to one and no to another. It's either yes or no to the whole thing. The reason that you're doing that is because under the settlement agreement, Canada has to pay the money into a trust account. So you have to have a trust account established in order for Canada to pay the money. So that's why you can't just approve the settlement agreement without also having a trust agreement established in accordance with terms of an agreement that you have established. So that's why it ends up being a package together. So I'm going to go through that. I'm going to move on, so there are certain requirements in the settlement agreement that talked about the trust and the trust account. And we have to meet those requirements. And basically, it is that until these shortfall acres are purchased and put into reserve status, the entitlement monies cannot be used for any other purposes other than to purchase the shortfall acres. So that's one thing that we have to meet. So those 4,352 acres had to be purchased first and put into reserve status before you could use the money for other purposes. That's the entitlement monies, okay? After the shortfall acres acquisition date, then the entitlement monies could be used to purchase more land, as David talked about, up to that equity quantum, or for band development, as that term is defined in the settlement agreement. So, what is being proposed for you guys, and what we're going to talk about tonight and what you'll be voting on, is the amendment of the specific claim trust. There's a number of proposed amendments to the specific claim trust agreement. You know, it's going to become known as the Mistawasis Legacy Trust if it is approved. Then all of the specific claim trust property that's currently in there will just remain in the trust account. There's about $600,000 in trust property. That amount goes up and down every day depending on how well the investments are doing or not doing. There's also some land that's been purchased, 4,606 acres. So that's part of the specific claim trust. That's trust property. That land will be included, it will remain as part of the trust property. And then Canada will contribute on the First Nations' behalf, will pay the entitlement monies into that same trust. Okay? Now, I just wanted to put this up because David talked about some amounts, and the amount that David talked about, all of it is not going to go paid into the trust by Canada. Some of those funds, the negotiation costs and the ratification costs, have already been paid directly to the First Nation, and they're used to do the negotiations and for this ratification. I do highlight the one up there in red, the additional costs. When Mistawasis was going through the process, they said to Canada, we need some further funds in order to complete this process. And Canada agreed to provide an additional $142,500. But they wouldn't pay it directly to Mistawasis like they did the negotiation costs and the ratification costs. It's going to get paid into the trust account as part of the entitlement monies. Now, I just highlight that for you, and just so you, when I come later, I talk about that just so you're aware of that. So, I know this is a big topic, and talking about, why do we have one trust? Why are we saying one trust? Why not do two trusts? Why not just leave the specific claim trust the way it is and then develop another trust that would deal with TLE? And you could have done that. That was an option that you could have followed. And as I said, when we first sat down and we started talking about it, we said, well, why don't we just have one trust? Both trusts, the mandate of both trusts was going to be to purchase land anyways, so why not put them together? And we looked at that, and we considered it. Louis ran some numbers for the council, for the people that were discussing it, and it became really clear right from the beginning that this was the best way to go. Okay, and I'm going to go through why that was the case. Okay, so there's going to be cost savings in having one trust as opposed to having two trusts, because it costs money to operate a trust. You know, you got trustees, you got employees, you got investment advisors, you got the bank, the institution, they have fees. And when we looked at it, Louis did an estimate. He thought it would be about $150,000 a year in savings to have one trust as opposed to operating two trusts. So we looked at that over a 25-year period. Over 25 years, $150,000 a year, that comes to $3,750,000 that would be saved in just cost, on annual cost to operate the trust. But if you run that number, that savings at a 7% rate of return, that becomes a savings of, you know, additional money that would be earned by the trust of $10 million. So that over that 25-year period. So that was a lot of money. And that was one of the driving factors that came into the decision to say, let's go with one trust, and let's make sure we have one trust as opposed to two trusts. In addition, you know, we've learned a lot of stuff over the years. You know, I'm one who will admit that. The specific claim trust, while it was drafted, you know, that's 20 years ago. It's a long time. Things have changed. We've learned a lot. And one of the things that we've learned is about investing of trust property. And in my view, it can be done better. And we made certain changes in the investment, or we're proposing certain changes in the investment provisions to allow that to happen. And I'll go through that with you. But right now, the current trust is getting about 5%. You know, they have certain restrictions that they have to follow, and those restrictions are preventing them from really getting the best return from the money that it can be achieved. In my view, you should be able to get a better rate of return, and right now what is being discussed is 7%. The current trust is about 5%, so that's a 2% difference. And 2% difference in a rate of return is a huge amount. When you start talking about compounding and investing, we calculated that additional amount that could be earned, just that 2% over that 25-year period, at $25 million. So Louis ran the spreadsheets and he came up with that a number. So if you just add those two things together, that's $35 million that would come to you as opposed to just being wasted or not earned. Okay? So it was also time to update your trust. I mean, the specific claim trust, as I said, was 20 years old. It did its purpose. The trustees did the best they could with it. You know, there's still the money there, $14,600,000 plus, you know, all the land that they purchased and put into reserve status. So it did its work, but it was time to change, in my view, because we've learned a lot of things over the period. Purchasing land, you know, if you're going to have two trusts, then you have two groups trying to buy land, right, as opposed to one group. And it could cause confusion, and I think it would be more efficient to have one trust as opposed to two trusts. And then the last thing is the distribution to the members. And I know there was a question about that, and I'll address that here. Without the amendments to the specific claim trust, the amount that is being proposed for the distributions could not happen. Okay? And I know there was a question about, well, you could have taken some of the entitlement monies and you could have used that to make a distribution. And that's correct. You could have done that. In fact, Canada was prepared to do that. They were prepared to allow you to take some of that $30 million and use it, but it was a limited amount. Right now, if you go into the agreement, you'll see there's a provision that allows up to $300,000 to be taken up front if the First Nation wanted to, but they didn't. We're not going to do that. That's not what the council wanted to have happen. Canada was prepared to go up to allow up to $1,200,000 to be used, and you could have used that money to have made a per capita distribution, okay? So that's far less than what is being proposed. That's about a quarter. So instead of the $2,000 per member that is being proposed to be paid, it would be $500,000. And I know you're going to come with a question, but I thought you were waiting to questions till after
when can we ask questions? That's why sorry I wasn't here at the beginning. I just want to know, when can we ask questions?
When we're done, and then we'll answer any questions that you want.
Okay. When I came in, they were asking questions to David, so I just thought I'd ask.
That's what we've been doing at all the meetings, so just let us get through the presentations, and maybe we'll answer your question before you get there. But at the end, we'll answer any question you want.
Yeah, for sure.
Okay.
Yeah, I'll write them down.
So, without these amendments, there could have been a per capita distribution, but it would be, maybe $500 a member as opposed to $2,000 a member, okay? Now, I'm going to go through a summary of what the amendments are. I'm not going to talk about all of the amendments. If you want to see it, I've got a copy of a red line version of the trust agreement. I know Roger has it, Lawrence has it. You can see every proposed change. My computer tells me there's about 1,200 and some. Yeah, there you go. There's a copy of it. There's about 1,200 and some proposed changes, with all the formatting and number changing and stuff like that. Now, the structure of the trust is not going to change. It's still going to be the same as the current structure of the specific claim trust. There's still 3 parties to the agreement. There's still the First Nation as represented by the Chief and Council. There's still the individual members acting as trustees, 5 trustees, and the current trustees will just continue being the trustees. The only thing that we're changing on that is the terms. Their terms would, and I'll come to that. And then the institution. There's still going to be an institution. In this case, it's being changed to Royal Trust Bank of Canada. They went through a selection process, and Royal Trust was identified to be the institution. And in fact, the property's already been transferred over to Royal Trust from CIBC. There's still 3 parts in the agreement. Part 1 that deals with the trust arrangement between the First Nation and the trustees. Banking arrangement, part 2 with the institution. So what's the institution responsibilities? And part 3 is just further assurances and amendment provisions. So it looks the same, okay, as the current trust. The name of the trust would change. It'll go from the Mistawasis Specific Claim Trust to the Mistawasis Legacy Trust. We had to make certain changes in the agreement to comply with the settlement agreement, the TLE settlement agreement. So there's a number of changes that do that, but basically we needed to ensure that the shortfall acres were in fact purchased and put into reserve status. And I'm going to come to that in a little bit with this land that's already been purchased by the trust. An annual payment is being proposed that would be made to the First Nation each year. It would start in 2023, April of 2023. The first 4 years would be $750,000 that would be paid out of the trust to the First Nation, what is referred to in the agreement as the revenue account. Then, beginning in the 5th year, 2027, and this would continue. It's 2%. but it would continue until all the land is purchased. What is referred to in the amended agreement is the full acres, and I'll talk about that. Until all the land is purchased, it will remain at 2%. So we don't know when that's going to be. It could be in 10 years, it could be in 20 years, it could be in 30 years. Well, until those full acres are purchased, it'll remain at 2% of an average of the preceding 5-year value of the trust property on December 31st. After the full acres are purchased, then that percentage would increase to 4%, and that amount would be paid on an annual basis. So what is this? This is replacing what is currently in the trust agreement, what is referred to as the specific claim development request. So the First Nation, the council could make a request for money out of the trust, and then there would be a process that would be followed. The members would vote on it, and then if they approved it, then the money would get paid out of the trust for that specific claim development. That whole concept is being removed. There's not going to be an ability for the First Nation or the council to make any more requests for money out of the trust. They're going to get the annual payment, and that's it. It just happens automatically. The trustees and the institution do their calculations and tell the First Nation what the amount is, and then every April 1, beginning in 2023, that annual payment gets paid out. Now, as I talked about the full acres, it's still going to be a requirement that all of the land be purchased. You don't have to do that, and even before, when you did the specific claim settlement, you didn't have to buy the land, but you said as a community that that was a priority for us to get all of those land purchased and back into reserve status. That's still going to be a requirement in this trust. So what we've done is we added the remaining acres to be purchased by the specific claim trust, the 9,465.15 acres, and the entitlement acres that you're allowed to purchase under the TLE settlement agreement, the 29,394.18 acres, the equity quantum. Those, the trustees have to purchase. Okay, so that's going to be a priority. That's going to be the first thing that they have to do. And that'll be one of the things that they will need to focus on, just as they're doing right now. The investment provisions. There's been proposed changes to the investment provisions. And this is really just from experience. Things that I've seen, things that Louis has seen, just from seeing what other communities are doing with their trust, and what is the best interest of the community, how to do it the best way. So we're making some changes to that to ensure that the trustees are going to be able to do a better job of investing the trust property. The biggest change is going to be the requirement for the trustees to hire what is referred to as an investment consultant. This is a person or a firm that just provides advice. They don't sell products, they don't sell investments. All they have, they have a requirement to have what is referred to as a certified chartered analyst. It's the highest designation that a person in the investment industry can get. And they have to have this person there working with them and helping them go through the investment process, selecting the investment managers, monitoring the investment managers, and making sure that they're doing the job that they were hired to do. Right now, the specific claim trust uses CIBC Wealth. And there's nobody telling them other than CIBC Wealth whether they're doing good or not. Well, what do you think they're going to say? Oh, we're doing a fabulous job for you. And how do you know? By requiring this individual to be hired, or this firm to be hired, you'll know. And they will monitor it. And there'll be a report every quarter. There will be a report annually. And that'll go to the trustees, it'll go to the chief and council, it'll go to the members if you want, and you'll get to see what they're doing, okay? And how well they're doing. The definition of investment manager, we're changing the definition. And what we're doing is really limiting who the trustees can use as an investment manager to actually invest the money. And these are very, the definition, if you look at it, it's kind of complicated. It's like that for a reason. It was a definition that I worked with an investment consultant with, and also a lawyer from Vancouver who specializes in the investment industry. These are the firms that you want to have looking after your money. They're called discretionary money managers. These are the people that Louis and I use to invest our money. And this is the only kind of people that you want investing your money. They do a fabulous job. And you'll get the benefit of that. It'll require an investment policy, although there isn't a requirement currently in the specific claim trust for an investment policy, and there is one in existence right now. But it's going to change, I can tell you that, because it's going to be, with the involvement of the investment consultant, it'll get changed quite a bit. And then the last thing that we did is we changed, or proposing to change, Schedule B, authorized investments. The current definition has certain restrictions in it, and those restrictions were preventing the investment of the trust property in a way it should be invested for the long-term benefit of the community. We're proposing it to be changed to what is referred to as a prudent investment standard. This is the industry standard right now. It allows the trustees to do what they need to do to set up a proper portfolio and to make sure that they can do the things that should be done in order to get the best possible return. So that's an important change. That's the one that probably one of the biggest things that needed to be changed in the specific claim trust, in my view, to ensure that it's working better for you. Minimum amount, there's still going to be a requirement for a minimum amount, but it's going to be changed. It's supposed to be changed to a set amount, $25 million. The trust property could never go below $25 million at any time. And the trustees and the institution are going to be responsible to make sure that doesn't happen. There are two exceptions, and I'll talk about that in a little while. But generally, it can't go below $25 million. So that's being changed from right now what's in the specific claim trust, the formula-driven approach, depending on how much earnings there were, and then there's certain percentages, and it was a little bit complicated to operate and to keep going. And I know Louis would do the audit, and he would have to make these calculations, and it wasn't always easy for the trustees to understand, well, what was the minimum amount, or are we maintaining that minimum amount? Per capita distributions, as we talked about, right now the specific claim trust does not allow for any per capita distributions. You could not use any of the money in the specific claim trust to make a per capita distribution. So we had to make that change to allow for the per capita distributions, or else this couldn't happen. So these changes will allow for two types of distributions. The first one is a one-time payment to every member who is 18 years of age or older on the date of the ratification. $2,000, it'll take about around $4.5 million to make that payment. We added a little cushion in there just to make sure that there was sufficient funds, so up to $5 million can be used for that. There's also a provision that is being proposed to be added that would require or allow for a payment to every member who turns 18. On their 18th birthday, they would be entitled to $2,000, okay? And that'll just go on forever. It won't, there's no cap on it. It just continues into the future, so every member who turns 18 gets the money. The way it's set up is it's really a reimbursement to the First Nation. The First Nation will make the payment, and then they can apply to the trust to get reimbursed for making that. So in a year, if there was 10 members who turned 18, $2,000, that's $20,000. First Nation would bankroll it and then ask for the money back from the trust on an annual basis. That amount, by the way, there is a provision, the 2,000, it's set unless the council and the trustees agree to change it, and they have the ability to change it. They could increase it, because we know $2,000 today is not worth the same as 2,000 in 10 years or 20 years, okay? So they could increase it in some fashion if they felt that the trust property could accommodate that increase, and those members who turn 18 could get more than $2,000. There were some sections like Section 8, it wasn't needed, so we're just proposing that it be removed. It is just really unnecessary. Income tax rules, we're changing the mechanism to get around income taxes. Louis is going to talk about this in his presentation, but all trusts are taxable entities. It doesn't matter who sets it up, who's the settler, whether it's a First Nation or an Indian, it is a taxable entity on any income that it earns, and it's taxed at the highest marginal rate. And Louis will tell you it's 47.5%, and we don't want that to happen. All we've done, the goal is still to make sure there's no income tax paid. We just streamlined the approach to make it easier for the trustees to operate. The trustees, the rules for who can be a trustee, how do you become a trustee, when are you removed as a trustee, all remain the same. There's still that selection committee. The only thing that we're changing is, as I said, the terms, and I'll talk about that. And we did remove the requirement for bonding. There was a requirement in the specific claim trust for bonding, and we're proposing that to be removed as part of the amendments. It's never been used. It was something that the council could have requested from the trustees. They've never done it. And the reason they've never done it is because bonding for an Indian residing on the reserve is very difficult to obtain. It's just something that is generally not provided because you just don't have the ability to get at the assets. The bonding company doesn't have the ability to get at the assets of an Indian because of Section 89 of the Indian Act. And it's expensive. If you were going to get this bonding unit, if you could get it, it's prohibitively expensive to get, and you would just be paying money out, in my view, that would be not worth and not in your best interest to pay out. And we've never had a problem with the trust. There's been no issues. The trustees are doing what the trustees are supposed to be doing. So, that's why I think in a large extent the council just said, we're not going to require it anyways, even if you could. Powers and duties, these sections are generally going to be the same, although we've kind of updated them to more current standards, and I'll go through that with you in more detail. So Article 15 of the trust agreement talks about a requirement for a member resolution, so members to vote on certain things, particularly these requests that the council can make for specific claim development requests. Because we removed the ability for the council to ask for funds for specific claims, developments, it was not needed, so we're just proposing it be removed. Conflict of interest, we're proposing that the conflict of interest rules be changed, and that's largely because Mistawasis has passed its own financial administration law, and that law, there's a schedule to that law that talks about conflict of interest, talks about conflict of interest rules that the council has to follow, employees of the band have to follow. In fact, contractors of the Mistawasis, Louis and I have to follow that. David would have to follow those rules. And so we said those rules should also apply to the trustees. So they still can't act in a conflict of interest. The rules are just being proposed to be changed that they have to follow. We're proposing a new section be added that deals with the council duties, just so that it's in black and white for the council to say, well, what are our responsibilities in this agreement? Don't have to look all over the agreement for it. They can go right to the section, say A, B, C, D. These are the things that we're responsible to do as a council. And then directions, that's still remaining the same. So you'll see in the current specific claim trust, the only way to get money out of the trust account is by the trustees signing these directions that there are at the end of the agreement. We're still going to have that as a requirement, but the directions are going to change and are just reworded to comply with the new provisions in the agreement. I like pictures. I find that it's easier to look at it, understand it. This was a chart, a slide that Louis and Lasha, my sister, would have presented when you guys were talking about the specific claim trust and when you were voting on it, okay? So this sets out, you know, on a one page, how the trust works, your current specific claim trust. So, you know, you have the boxes say what the money could have been used for. Right now, you're down to specific claim trust requests and purchasing land and investing. And then the band account was the tax dodge. We were using that to get around the tax issue. And then you have the authorized expense. This is what it'll look like now if the proposed amendments are accepted. And the boxes show how, in what way the trust property can be used, and we'll talk about those in a little bit more detail, but you can see the transfer to the First Nation up front of that $5,142,500. Purchased land, those future distributions, authorized expenses, they still need to pay their authorized expenses. They invest the money, and then there's that annual payment that goes into now what will be referred to as the revenue account, which will then be used by the First Nation for whatever purposes it wants to use it for, as long as it meets the definition of band development. So those are a summary of proposed amendments. I'm going to go through the agreement with you. Not in real detail, but I'm going to kind of run through them with you so you can understand the structure of the trust. So the definitions, there's 69 terms that are defined. Whenever you are reading through the agreement or the schedules and you see a term that is capitalized, that means it's been defined. You need to look back at the beginning under this section to see how that term is defined, to understand what the term means. Some of them, I'm just going to go through a few quickly. Acquisition cost legal, those are the legal costs that will be incurred to actually complete the purchase of the land by the lawyer. You know, their legal fees, the land title registration costs, whatever it may be, those would be their costs. Those costs can be paid directly out of the trust account to the lawyer into their trust account as part of the land purchase process. Acquisition costs, trustees, those are the costs that will be incurred by the trustees to determine what land they want to buy, you know, whether they're going to do land appraisals, they're going to do sites, you know, need to go see it, whatever it may be. Those are those costs. Those costs are included in their authorized expenses and are part of the budgeting process. So there's a control put on them so that they just can't go and spend whatever money they want to in going through this process. And some of you may have heard in the news that has happened. There was some failings in some of the older trust agreements that did prohibit that from happening, and some of the trustees abused their positions, spent way too much money. In fact, some of them went to jail over that. So we're not going to rely on the court system to police it, we're going to actually put it in there and make sure that it doesn't happen, okay? Annual income is just a taxable income, and we'll talk, Louis was going to talk about that, but that's an important definition for income taxes. Authorized expense account is that account that the trustees will establish to use to pay their authorized expenses, and then the authorized expenses are the things that the trustees would incur to operate the trust. And if you look at the definition, there's a long list of things that were included in that. We'll come to it in Article 10, but there's a whole process of how much money can go into that account to control the trustees' spending so that they're not overspending. Authorized investments, that's what is set out in Schedule B. Band development, this definition came right out of the settlement agreement. Because we have to comply with the settlement agreement, we had no choice but to use this definition. It is a broad definition. You know, if you can think of it, as long as it benefits the First Nation or the members of the First Nation, then you can do it under band development, okay? So there's really nothing that would limit what you could do. I mean, a trip to Hawaii, that's not a band development, you know. I mean, obviously, it's got to benefit the community in some way. So housing, infrastructure, you know, schools, hockey rinks, you know, things like that that could be used. Economic development, those are the kinds of things that are being contemplated there. Beneficiary is the First Nation and all members on a collective basis. So you don't individually have an interest in the trust property. It's on a collective basis. The full acres we talked about, that's the total acres that the trustees need to purchase. Investment consultant, you know, we talked about that. That's that individual that's going to provide advice and work with the trustees to get the investment of the trust property done. Investment manager, that's the firm that would actually be hired to do the investing. And investment policy is the policy that everybody, the trustees, the investment manager is going to have to comply with in terms of investing. Now that may limit what investments they can do. That'll be something that'll be determined by the trustees with the assistance of the council and the investment manager. Minimum amount is at $25 million. Revenue account, that's the account to be established by the First Nation to receive that initial lump sum of $5 million, and then to receive the annual payments. So it doesn't just go into the band account, it goes into this account, and then there's a tracking mechanism of what money went into that account and how it was spent out of that account. Trust account is the current specific claim trust, which will become known as the legacy trust if the amendments are approved. And then the trust property is the property that is part of the trust, and that's all the money that's in the trust account, all the authorized investments, and any land that's been purchased, and as well in the authorized expense account. Schedules, there's 7 schedules. The first one is the undertaking of trustees. It hasn't changed. It's the same schedule that is currently part of the specific claim trust. Every trustee has to sign this or else they can't be a trustee. Authorized investments, Schedule B, and then C, D, E, F, and G are the various directions that would need to be signed by the trustees directing the institution to disperse money for the specific purposes that it can be used for. Article 4. This is the most important part, section in the trust. This sets out how the money can be used, the trust property, and how it can't be used. Okay? So there's a couple of exceptions. You know, they have to make sure that the minimum amount is there. They can't take money out of the trust account for any purpose if it would result in the value of the trust property going below $25 million. Trustees have an obligation to do that, and as I said, the institution also has an obligation to ensure that that doesn't happen. The 2 exceptions are for authorized expenses, They can still take money out and put it into the authorized expense account to pay for the expenses, even if that would mean the trust, the value would go below 25 million. You still got to operate the trust. There's nothing you can do about it. You know, you're going to have the ongoing expenses. And the other one is Section 8.3, and I'll come to that, but really what it is a mechanism that if Revenue Canada ever came and said, we're going to tax you, or the trustees felt that there was a problem coming, you know, they got advice, you know, Louis would do the audit and he would come back and say, look guys, there's a potential problem from tax here, then they can deal with it immediately through that section. And they could take money out of the trust account and pay it to the First Nation, even if it would go below 25 million. Because you don't want to pay 47.5% to Canada, you'd rather pay 100% to the First Nation. So the first thing that you can take and use the trust property for is this $5,142,500. The 142, you recognize that amount earlier when I talked about it. So the First Nation is spending the money, but Canada said we're not going to pay it directly to you. But the First Nation needs that money to cover its costs, so that's going to come out. The trustees are going to be directed to pay that to the First Nation, and the First Nation will just reimburse itself. Then approximately 4.5 million will be used for that distribution to the members who are 18 years of age and older of $2,000. And then whatever's left, we've estimated approximately 500,000, but it could be a little bit more, it could be a little less. That could be used for band development by the First Nation. 4.2B is those future distributions to the members turning 18. C, they can use it to purchase land. D, they can invest the trust property. And you can see at the end of each of these is the article. All these articles after this just give more detail in terms of what rules they have to follow in order to use the money for that specific purpose. Annual payment, Article 9, that's that payment that's going to go annually to the First Nation, and then authorized expenses, paying money into the authorized expense account to pay for authorized expenses. Authorized expense account, any money that's in that account can only be used to pay for authorized expenses or to invest if they want. But generally, the idea is to keep not a lot of money in that account, just enough for the trustees to cover their expenses. 4.4 sets out some prohibitions on how the trustees can use the trust property. No more per capita distributions. Can't use it to make other than what's already set out in the agreement. Those two distributions that I talked about. They can't lend the money. They can't use the money as security for a loan. They can't be attached in any way. So you know, you're not going to lose the trust property because they're going to use it as security for some loan. 4.5, once some of those distributions are made to the First Nation, 4.2A, that's that 5,142,500. B is the future distributions, and E is the annual payment. Once they're paid out, the trustees have no more responsibility for those funds. How they're spent is not their doing. They have no responsibility or liability. That's the chief and council. Okay, so don't look to them how those funds are spent, because they have no control over that. Article 5 just sets out how that 5,142,500 is to be distributed and what it's to be used for. It talks about also the future distributions. Article 6 sets out the rules for purchasing land. The trustees are in control of that in terms of they're going to be responsible for making the purchase, but they can't do it on their own. They always have to have chief and council approval before they can purchase land. The rules here really haven't changed. or the proposed amendments really aren't changing it significantly from what's in the current trust agreement. The one thing is section 6.1 was added, making it a requirement that before any of the entitlement monies are used, that you can only use the money, you have to purchase the shortfall acres. So those 4,352 acres. Now, as you heard, they've got 4,606 acres purchased right now. They bought it. And in fact, they had made an application to have that land placed into reserve status under the specific claim settlement agreement. And when we sat down, and I said, why don't you guys change that? Why don't you put those acres towards your shortfall acres so that you can get that done immediately? And that's what's going to happen. The trustees have removed the application to have those lands set apart as a reserve under the settlement agreement. And if this is ratified, then they will make an application to have them set apart as a reserve in accordance with the terms of the TLE settlement agreement, which means you're going to hit your shortfall acres almost immediately. As soon as Roger can get them into reserve status, you've hit it, and then you don't have this hanging over your head that you need to do this, and then it opens up for you what you can do with the money in terms of purchasing land. Now, the process is the same. They make a written recommendation, and if you look at section 6.2A of the trust agreement, it'll set out exactly what information has to be provided by the trustees to the council in terms of this recommendation. The one difference here is in that information, the request for the recommendation is they have to advise the council under what settlement agreement the land that's being purchased should be set apart as a reserve, under the TLE settlement agreement or under the specific claim settlement agreement. Okay, so that'll be part of it, and there'll be a discussion, I'm sure, between the trustees and the council on what is the best course to take. But initially, it's going to be the entitlement lands, because you want to hit that. You want to use the money for that first, particularly when it comes to farmland. If you're going to purchase urban land, you can do that under the TLE framework agreement or TLE settlement agreement. But in my view, it's much better to do it under the specific claim settlement agreement. It's easier to do. And the one thing you don't have to pay for is school tax loss under the specific claim. Under the TLE, the rules require you to compensate the school divisions in the urban municipality for their tax loss. And that can be expensive. That can be a real big expense that needs to be paid. So it's all, that's something, there's an advantage for you guys. You guys can make a determination what is in your best interest, which one should we use, and which way should we go. Trustees cannot purchase any land until the council gives their approval. Once the council gives their approval, then the trustees arrange for the money to be taken out of the trust account by the institution, and it goes to a lawyer's trust account, and the lawyer then completes the purchase. The land is then held in the holding company. There's a holding company in existence now. Those 4,606 acres are being held in. And then once it goes to reserve status, it goes into Her Majesty the Queen's name, and it becomes a reserve. We have to add in a couple of provisions, 6.3 and 6.4, that deal with lands that may have been purchased but can't get into reserve status for whatever reason. If it is before the shortfall acre acquisition date, then the land has to be sold and the money has to be returned to the trust account. If it's after the shortfall acres acquisition date, then the First Nation, the council has a choice to make. They can either require the land to be sold and the money returned to the trust account, or they can keep the land and just keep it in fee simple and use it whatever it wants. And in that case, it would go to the First Nation, and the trustees would have no responsibility for that land after that point. 6.5 deals with this upset price. David had talked about it. Canada wants to make sure that you got sufficient money to purchase the land. I did the calculation there for you, and you can see the upset price. It's almost $7,000 an acre. You can buy a lot of farmland with that. Couldn't buy any urban land, I doubt, with that amount. But the point is that it's a useless requirement for you guys because you already got your shortfall acres purchased and waiting to go into reserve status. So really you're paying zero. You're using zero of the entitlement monies towards those purchases. Trustees are continued to be responsible to get the land into reserve status. They're also going to be responsible to administer and look after the land, lease it out or whatever until it goes into reserve status. Still the requirement that any money that is earned on leasing the land or whatever they do with it until it goes into reserve status has to be returned back into the trust. And then once it goes into reserve status, that's the trustees. Their responsibility ends and it goes into the First Nation and the land code would then take over. Investment. If you look at and you compare the investment provisions, you'll see they're pretty much the same. Said there's minor tweaks such as the investment consultant requirement, the delegating of the authority to the investment manager or managers. In fact, I think right now they're talking about with the investment consultant the possibility of maybe more than one manager. And there's a requirement, and you can see 7.7 to do the quarterly and annual statements and to have everything monitored. The institution will act as the custodian through the arrangements and agreements with them, and that's already in place with Royal Trust. Okay. Annual income, this section just deals with it's taxation, really. If there's any income that is actually subject to taxation, there shouldn't be, but if there is any, then that is deemed to be the First Nations property, and as Louis will go through with you, you'll see that the First Nation doesn't pay tax, so there's no tax being paid. And it doesn't have to be paid to the First Nation, it's just an automatic thing that happens under the terms of the Income Tax Act. 8.3, I talked about a little bit earlier, and I'll highlight it here, is that if the trustees see any potential negative tax consequence that's coming, then they have the ability to immediately address it and make sure that that doesn't happen, okay? Annual payment, Article 9 deals with the rules for making this annual payment to the First Nation, and these rules just have to be followed by the trustees and the institution to get the money paid to the First Nation. The one thing I will highlight there is section 9.5. This requires the First Nation to have prepared what is referred to as a statement of receipt and uses of funds that have been received. So, they're going to receive in the first year $750,000. So we received $750,000, and this is how the $750,000 was used. And it would have to itemize that. They need to then have that statement presented to the members. So stand up here and present it. This is what we did. This is what we received, and this is how we spent it. They need to post a copy of that on the web page, Mistawasis web page, and they need to provide a copy to any member on request. So anybody that wants to see a copy of that, you get every right to get it, and they have to provide it to you. So once a year that would happen. Article 10 deals with the authorized expenses, and this really hasn't changed the process. It's still through budgeting. So in the fall time, this time of year, the trustees would prepare a budget for next fiscal year. They would then present it to the council, and the council will either approve it or not, or have discussions. The one thing that we did do, though, is we did put a cap, and that's in section 10.3. The amount that can be spent on authorized expenses in any year is limited to 1.5% of the market value of the trust property from the prior December 31st. There's one exception and that is in extraordinary circumstances. It could exceed 1.5%. For an example, we talk about this at the other meetings. Well, what if the trustees were being sued for some reason, or they needed to sue somebody under a contract that they entered into that they weren't doing the work that they were supposed to be doing? Well, then you're going to have to hire a lawyer. It's going to cost money, and you're not going to budget that. And if that ever happened, it's never happened, but if it ever did, then they could take more than that 1.5%. And there's the rules are out in there, what needs to be provided to the institution to get the money out, and then what the money can be used for. And if you look at 10.12, you'll see that it's really a check. It's just like any other operating account. It would be a check that would be written as long as it's signed by 2 trustees, and those are approved in advance by the trustees. Trustees, Article 11, as I said, really no changes here. Still 5 trustees, still have to be members, still have to be 18, and so on and so forth. Those rules are still the same. There's still the independent selection committee that has to be established to, when terms end, or if there's a vacancy to select the trustees and then have it approved by the council. The initial trustees, as I said, are going to be the current trustees. We are changing the term. Instead of the spring, it's now going to be the fall. Louis and Anita will be 3 years term, and then Lawrence, George, and Robert would be 2-year terms. And then after that, it'll be 3 years. And then it'll just continue on being 3 years. And 10.9, you'll see that requirement to sign that undertaking in Schedule A. Article 12 deals with trustee powers. It's been changed, but it doesn't in effect mean anything different. It just gives the trustees the powers they need to do to get the job done. Trustee duties, it sets out specific duties of the trustees. 13.1, you can see, is the overarching duty of any trustee. Okay, they have to act with reasonable care, diligence, and skill in the performance of the duties in the best interest of the beneficiary. Not their best interest, in your best interest. That's what the courts will require. Okay. They still have the requirement to do certain accounting and reporting. It's the same as in the current specific claim. They have to provide certain information to the council. It's still the same information. They have to permit members every reasonable opportunity to review the trust records. If you want to review them, you just phone them up and say, I want to come in, and you'll make an arrangement to come in, and you'll be able to go through all the records, all the ledgers, everything that is there. 120 days are still a requirement for the annual report. So once a year they'll do the annual report and provide it. The one big difference here is there's no more requirement to have that annual report mailed out. When we were talking about it, Roger said, well, it costs a fair amount of money to mail it out, and most of them were just returned anyways. So that requirement is being proposed to be taken out. It still has to be given to the members. You want it, you get it. It has to be posted in the administrative office of the First Nation, and it has to be posted on the First Nations webpage. They are still, responsible for their own negligence in performing their duties, but they are given an indemnity, so as long as they're complying with the trust agreement, then they are protected. Article 14, trustees meetings, there was really no change to that provision. It just sets out some governing rules to govern meetings of trustees. Conflict of interest, as I said, there's still that requirement to avoid conflict of interest, but it's being changed. And duties of council, we talked about that. That's a new section being proposed to be added to set out what the council's duties and responsibilities are. Part 2 deals with the institution's responsibilities, Articles 17 to 19, and what the institution has to do. Addresses opening of accounts, rules for when the institution can release money from the trust account, what information has to be provided to them, and their responsibility to ensure that the minimum amount is maintained at all times. So Article 17 is opening of accounts. Article 18 deals with that requirement to maintain the minimum amount. And so if the trustees come to the institution and say, we want $2 million to purchase land, and the result would be that would put the value of the trust property below $25 million. The institution just says you can't have it. That's their responsibility. They could not release that money if it would go below the minimum amount. And then sections 18(4) to 9 just deal with what has to be provided to the institution in terms of documentation by the trustees in order to release the money for the various purposes. Article 19 just deals out with some miscellaneous terms related to the institution, and really it's the same provisions that were in the specific claim trust. There's no changes that are. Article 20 deals with either the replacement of the institution. Maybe you don't want to use them anymore, and that's happened now I think 3 times, where the trustees have moved to a different institution. It was Pisos Trust, and then I think it went to CIBC, and now it's in Royal Trust. That can happen. Okay, there's a process to follow. But the institution may decide that they don't want to be the institution anymore, and they could resign, and it addresses what has to happen in those circumstances. Further assurances, basically just talks about a council resolution being passed in accordance with the requirements of the Indian Act. Amendments. Article 22 is amendments, basically the same as what is in the current trust agreement, the specific claim trust. 22.1 allows the trustees and the council to immediately amend the trust agreement if there's changes in the law or policies of the government that would result in the trust being taxed. So the mechanism that we put in there is not working because the government has changed something, then they can immediately respond to it and make sure that doesn't happen. 22.2, again, the trustees and the council can amend the agreement on their own without member approval to address certain issues such as changes in the law or defects in the agreement to make it more efficient. As long as they get a legal opinion from a lawyer explaining the legal implications of those. They couldn't change section 4.2 through this mechanism. How the money could be used. 22.3 is the overarching amendment provision. So amendments then would need to have member approval other than what is set out in 22.1 and 22.2. You'd have to have a ratification vote just like is going on right now. You'd have the right to vote on and amend it in whatever way you want to do. Article 23 is notice, and Article 24 is other provisions, just some general provisions, and then the schedules. Schedule A, undertaking of trustees. Schedule B, authorized investments, and then Schedule C to G are those directions. Okay, and you can write that down if you want. As David said, I'm here to answer any questions you have. In fact, I have to make myself available after this meeting up until the ratification voting date, November 10th. You want to phone me, you want to email me, you have a question, you want to better understand what you're voting on, I'm available to you to answer those questions, to go through that with you. And I have to do that before I can sign my certificate. I have to say that I was available to the members and answered any questions that you had. Yeah, we still got to go through Louis, yeah. Yes, all the questions you want tonight after Louis is done. Yeah. Okay. wasn't my, that was the sorry, Lou. Yeah. No problem, no problem, yeah.
Sorry about that, Stephen. I'm
No
just,
problem, no
you know, like these agreements, there's a lot going on in them, and you're talking very slowly, and you know, it's really, some of these things can be forgotten and what's going to be asked, kind of thing. So some of the questions I actually have, you mentioned at the beginning that this wasn't about terminating the specific claim trust and that you were just rolling it into this new trust. The problem I have is, originally what you told our council is that you were terminating this trust. And the reason I say that is because a letter went out to our membership that says you were terminating the Mistawasis Specific Claim Trust. Right. When I spoke to Roger Daniels about the Mistawasis Specific Claim Trust, he said there was no termination clause in that agreement. That's what legal counsel said. Right. And I said, yes, there is. And I read it to him, and I said, unless they got a Financial Management Act. And I said, because then they can make amendments. But there's certain amendments you can't make according to that trust agreement. One of the amendments is 3.02. 3.02 is the per capita share distribution. So one of the things I want to ask, you're retained by Chief and Council, or are you retained by the trustees?
By the First Nation.
So did our trustees get independent legal advice in regards to all of this?
I'm not aware of them doing that, no.
I asked Roger, and he said, no, they actually didn't. So I have concerns for my members because I sat on a trust for 12 years, and I would have an issue if I was told that this was all okay, because at the end of the day, they're the ones responsible. Because when you look at the payout in Article 5, what does it say? Is it coming out of the Legacy Trust? No, it's not. It's coming out of the Mistawasis Specific Claim Trust. And according to the trust, it says there's only a one-time per capita share allowed. And if these trustees didn't get that legal opinion, that concerns me that they may be in breach of trust. I have no issue with TLE. TLE can create wealth creation for our First Nation. And the way TLEs are set up, revenue goes to the First Nation. And they can do all of these great things with it. They don't have to make proposals. They don't have to do all these things. But you're up here, and you're giving investment advice?
I'm not.
You did.
I'm just telling you from my experience.
What I heard was investment advice. Another thing you did is you provided real estate advice. That's concerning. Another thing, you also explained that the strategy for our First Nation going forward is to take the specific claim acres and create shortfall acres. And they'll be taking care of that shortfall. Where's the minerals?
Where's the what?
The minerals. Under TLE, they're responsible to also buy the minerals.
Yeah, well, you know what's going to happen with those 4,606 acres?
Actually, I'm under the impression that our First Nation can make that strategy.
You're going to get the mineral rights free of charge.
If they're undisposed.
If they're undisposed, and Roger's already looked at them.
Are they all undisposed?
As far as I understand.
And if that's the case, why weren't we informed? Because there's plenty of members that are here, that are aware, that know these terms, understand these provisions. Like, I don't understand. But you have provided the information. One other thing I'm also concerned about is, according to your trust agreement, you state that the current trustees' hands will be tied, basically, because they will not be able to purchase any specific claim acres until the shortfall acres are acquired and turned to reserve status. Is that not offside with the original settlement agreement with Canada, where it states that we have to have that 25-year time frame from June 12, 2001?
That time frame has been waived.
Do you have that in writing?
I had talked with Canada about it.
You don't have it in writing then? And we're going to vote?
I had prepared a letter for the chief to send to Canada He has said, he has sent it to Canada. I don't know, I'm not aware of a
Stephen.
response coming back.
I'm here to speak on behalf of our membership. I have the utmost respect for Chief and Council and our trustee team, and I know where they're getting advice from is from yourself. The trustees didn't receive private legal advice.
If
That's
they
a concern.
want, that's up to them.
Well,
And they're
are
not
they
being
not?
They're not being prohibited from doing that.
That's concerning. It's concerning. Did you tell them that?
They know that.
Do they?
Sure they do.
Anita is the trustee.
It's an authorized expense.
When I contacted the Land Claims Office and spoke to Roger, we always have great conversations. I know, like, first of all, I had no idea that he was actually one of the spokespersons in all of this, so I was like a little bit shocked that he's up here and helping him. But I thought it was Lawrence. But yeah, like all of these things are quite concerning that they're not brought up, like the termination of trust. Okay, somebody put it out there that there's a termination of trust. Let's change that.
Well,
was it not on the first ballot?
let me
Was that
address-
why there was a delay?
Let me address that, okay?
Okay.
We did talk about that initially, about terminating the specific claim trust and establishing a new trust. And then we looked at it and we got a legal opinion that said we can't terminate the specific claim trust.
So you got another legal opinion?
We did. We got an independent legal opinion done. And it came back and says, you can't terminate the specific claim trust. So we
When did you get that legal opinion?
It was in the spring.
I see. Okay, so according to the transfer to the nation, what it states on 5.3, any funds disbursed to the First Nation under Section 5.1 shall be deemed to be dispersed from the specific claim trust property.
Right.
So that's the trustees. This whole thing is about the trustees. And the whole Mistawasis Specific Claim Trust is about the trustees. It's their responsibility to protect that money. It's their responsibility under even the Trustees Act of Saskatchewan. They can be held accountable for this, and that's my concern. Can this agreement be changed prior?
Yes.
Yes, it can, right?
No. That agreement can't be changed.
Yes, it can.
What you're voting on can't be changed unless it's voted and approved.
It actually can be changed.
Which one are you talking?
You can change the whole agreement if members want it to be changed.
The specific claim trust agreement?
Your legacy trust.
It's no different than the specific claim trust.
Yes, it is. It's different. In the investment portion of this new legacy trust, you're putting all the responsibility on trustees. Whereas the old specific claim trust, this is the legacy trust, sorry, in the old specific claim trust, they were protected by the financial institution and the investment manager actually helping make those decisions.
It's exactly the same.
No, it's not.
Yeah, it is.
Okay, I have it with me,
Go ahead.
and we can compare the two.
We can compare the two.
They're not the same.
It's exactly the same. The only difference is the requirement to hire an investment consultant.
How was the specific claim trust invested already? How has it been invested?
They have retained an investment manager, CIBC Wealth, and
there was an investment policy created.
there was an investment policy created.
So how is this different and better?
The requirement to retain the investment consultant, an independent investment
But
consultant.
the trustees already did that on behalf of the First Nation and
No.
protecting that money.
I'm not aware of them having
Well,
done that.
they had an investment manager and an investment policy.
The investment manager and an investment consultant are different.
They could have had an investment consultant
They
or a
could have.
manager or whatever. It
They
was
could
up
have.
to them.
They could have, but they didn't.
But was it not working? Were we not making 5%, about 5% interest on an annual basis?
As far as I understand, they have been.
Yeah.
Okay. You can do better.
Pardon me?
You can do better.
And that's based on your investment advice.
I'm not giving advice. I'm saying you can do better, and I've seen it done better.
We will do better because we'll have more money to invest. The more money you invest, the more money you can make.
Well, yeah. But
And another thing you're changing within this agreement is you're saying that without the investment policy, you can only invest in low-risk investments. However, when you're talking to investors and they're dealing with money that has to be there in perpetuity, like the other agreement said that this money was going to be here in perpetuity, that you have to manage it in a way that's prudent, which sticks around, which makes money, which is low risk. And you get your low risk by a balanced portfolio and having it in a long-term investment.
Well, I mean, I'm not going to debate that with you. That's not my job here, is to debate that with you.
Oh, I just brought it up because you were giving it investment advice. But, like, when you look at this, so you're saying that this allows the investment consultant, did you say? Or investment manager? Who is it that you have in this new legacy trust?
Just to do, what's
Is it
the
a consultant or a manager investment?
There's both.
Oh, okay, because I just
The consultant,
trying to figure out
the
exactly.
consultant gives the advice.
Okay.
The manager does the investing.
Okay, so then they're allowed to increase the risk of the investment.
Based on the investment policy.
So you're suggesting that we can make more money by maybe having high-risk investments?
No, in fact, I think what you'll find is that
It's not defined in here.
I think what you'll find is that what is going to be suggested by the investment consultant is going to get a better rate of return with less risk.
See, like it sounds like Mistawasis knows what they're doing, and it sounds like Mistawasis has done a really good job. But at the end of the day, now we need more help. Like it's a little bit concerning. Like, why would we reinvent the wheel kind of thing? We were making money, we were doing well. The First Nation is going to get contributions from the trust. Now, if we have a TLE, it's automatically going to happen anyways. And that's the concern from me.
Is there a question in any of this?
The concern is this whole, is it offside with the original settlement agreement? And you said you don't have it in writing from Canada to state that that 25-year time frame is disregarded.
I didn't say that.
You don't have it in writing.
I don't.
Yeah.
I don't work with I haven't worked with the trust for a long time.
Okay. So yeah, that's.
I mean, I'll answer questions. I'm not going to debate this with you, but if you have a question, I'll happy to answer it.
I want to know if this can be changed.
What can be changed?
The legacy trust.
It can, with member approval. It can be amended in accordance with Article 22.3.
Okay.
If it is approved, in the future, it can be amended.
Okay. And then this whole specific claim thing that ties the hands of the trustees if, they have to just focus on shortfall acres. Are you going to back that up and guarantee that they can have that land turned to reserve status without a delay?
Well, no, I can't, because I don't know what that land is entailed. I mean, they're going to have to make the application and go through the process and deal with the third-party interests. And assuming there's no issues, it'll go into reserve status.
Right. And another thing I have concern about, I just want to bring up, why do they have a right to sell land that's under Her Majesty the Queen?
They don't.
It says that in your...
No, it says that if prior to the shortfall acres acquisition date, the land can't go into reserve status for whatever reason.
They can sell it.
They have to sell it, and the money has to go back to the trust account.
And what land is that? Any land?
Any land. They may have purchased a parcel of land, and they may have made the application for reserve creation, and Canada has said, for whatever reason, we're not prepared to put it into reserve status.
Okay. Another thing you said is that we're going to save money by combining the trusts, and you also state in your summary that our trustees may be confused and they might fight over one piece of land, which will increase the value of that property. I find that very sort of...
I didn't say that would happen. I said that's a possibility.
But you wrote it in the summary. So obviously,
I
that's,
said it could cause confusion.
that's something you suggested to the
Yeah, I
council.
said it could cause confusion and be less efficient, yes.
Right. Okay, that's all my questions right now. I might remember more because, you know, going through that long, drawn-out presentation, you know, I just wanted to get up and ask questions, but I just, you know, I just got to the point where it got sort of,
Well,
I missed it, so.
yeah, I mean, the idea of doing these, because we have to do them, we can be here till midnight, and Louis still got to get up here and do his presentation. And we can still be here to midnight after Louis does his presentation,
I'm aware of
answering
that.
questions. But the point is, maybe not everybody wants to be here till midnight to debate these things.
Well, I really appreciate everybody giving me the time to get up here and ask these questions.
Yeah. I mean,
And I apologize if I've taken up too much time, but I will actually ask more questions once they come up in my head and I go through the document a little bit further. And I'm appreciative of that phone number up there. I'm sure we'll have much more discussions.
yeah, I mean, go ahead. I mean, that's what I'm here to do, and that's what I'm obligated to do. So,
Like,
yeah.
it just feels sort of like deja vu because you were here telling us 20 years ago.
No,
that-
I wasn't, but my sister
you-
was.
Well, you were the trust lawyer right after the fact.
I did, yeah.
Yep. So it's odd that, you know, those can't be changed. It can't be changed within that.
Question, please, direct it to Stephen. If not, if there's any member that want to ask questions, then we still have another presentation to go. And after Louis' presentation, you can ask all the questions you want, okay?
Okay, one more question about the amendment. You said that the amendments couldn't be, you know, you can't change it, like you can't change this agreement. Is that what you said, something?
From the point, from now till it's voted on, no.
Till when?
From now until it's voted on, no.
Oh.
It can't be changed.
Oh, no, I mean about, what were you talking about when you were referring to the amendments in this new legacy trust? I want to know, I want to have an explanation on that.
So, let me just go back to it then.
Oh, you went, there.
Okay. Under 22.3, the members can approve whatever you want to do to amend it, as long as they ratify it.
Okay.
So in 10 years, you want to change this, you don't like it, then you can do that.
Or once the shortfall acres are acquired,
Or once the shortfall acres are acquired.
which could be really quickly, like you said.
Right.
Thank you.
I just want to I just have a comment here. Like, we were satisfied with the chief and council and the trustees and membership running this TLE and specific claim. But I'd like to have a calculation, like if you hire a manager or a consultant, we're so tired of money going out. Why pay these consultants and managers if our own band members, chief and council, and trustees can do it on their own, like they always did?
Okay, so what I heard there was, why are we going to pay this investment consultant? Why do we need to pay this money to the investment consultant? Why not just the trustees and chief and council do it? And you could do that, okay? From my experience, I've seen these people work with trustees, and I've seen how it works, and it works. They are worth their money. You will do better in your investment because you have them there. And that money you're going to pay to them is well worth it. And you don't have to take my word for it. You can ask Louis. I mean, he's seen it too. We've seen how it works. So that's why we're suggesting that you have this investment consultant. And it's not, I mean, they could do it now. Under the current trust, they could hire, but they haven't. This is going to make them do it. And they'll do a better job in the investment. And that's why. You had a question?
I just want to thank the Bernie Pachawi for the opening prayer. But the lady called her Pachawi, so. But anyways, I'd like to thank the former chief and council and the chief and council today for bringing us this far. And I know there's always going to be negativity, and no matter what we do, no matter what process, there's always somebody on the other side of the fence. Always. I seen that, I lived that all my life. So, but getting back to the amendment, say if we sign the 2,000, for the 2,000, but for our children, you said you can amend that down the road? Is that what you're saying? You can lower it or increase it?
They can
Either or, right?
Either or.
Either or.
Either or.
So why do you want to lower it?
Why would they lower
Yeah,
it?
for the children, why would you want to lower it?
I guess it would depend on what is going to happen. I mean, we don't know right now, sitting here, nobody knows how quickly and how much money the trustees are going to spend on land.
Okay, I don't want to take too long, but anyways, as an adult, me signing on behalf of my grandchildren today, 20 years down the road, it's like the chief said, some of us might not be here, but the cost of living in 20 years' time, at that $2,000 plus the interest, they're going to need that, not what we have today.
Yeah.
And that's the only concern I had about this thing. There's other things too, but we can go on forever, like you said.
And that's a good comment, and that was debated at the table when we were talking about. In fact, Louis ran a number of numbers for the chief and council and the trustees to look at, you know, what is the difference with inflation or without inflation, you know, not adding it, and you know, that's why we ended up including in that provision the ability for the amount to be adjusted. You know, hopefully it's upward.
Yeah. My suggestion is just to leave it on our behalf of our children down the road, because they're not here to speak for them.
Well, then they'll make that determination. Yeah. They'll be the chief and the council, or or the trustees. Yeah.
Okay, that's it.
Yeah.
Thank you.
Just one thing, like I am a social worker by trade. I've been a welfare worker for 30 years. And what concerns me, Stephen, is with that $2,000 payout that's going to happen to our band members. The people on welfare, they can only get $1,500, and they're going to be cut off welfare for 2 months, because all they get is $255 a month. And this, if they get 2,000, they can only get 1,500 is what I'm saying.
Yeah.
So.
Well, I mean, okay.
We reached out to the province, Ministry of Social Services, to have an exemption in place for up to $15,000 an exemption for it. But we wrote a letter to Lori Carr asking for that exemption for up to $2,000. We're anticipating that will come back positive, so that members won't be implicated by the payout if it is successful. Then again, as we resolve future claims, up to $15,000, we can get exemptions for you on that day. Just, I guess, in response to Norma Johnson's concern, I guess, with respect to the SA clients that receive $255 a month, we had reached out to the province and asked for an exemption. The exemption is up to $15,000, so we're just waiting for a response back from the Minister of Social Services, Lori Carr, in the province, and they do have that ability to give us that exemption. Thank you.
More questions? More questions? Sorry, Louis.
Good evening. I received an email this evening from Will Fraser out of BC, and he asked me to ask a few questions in regards. And he said, Tanse, my assumption is nothing has come up regarding the sharing of the meetings and dialogue for the many members who are not in proximity of scheduled meetings. These are questions I jotted down last week, so I have no idea if they have been addressed or are relevant at this point. So like many, my vote is not what they are hoping for. Who decided on the $2,000 offer? And I can answer those questions for him. Well, that one I can't, because I think I asked that question who came up with that $2,000 offer, and why that amount specifically. Where is that money coming from now? And I can tell him, as I think he's listening now. So who decided on the $2,000 offer, and why? Yeah, and why that amount specifically?
Okay, thank you for that question, Anita Johnstone. It's relating to the, I'm sorry, my memory.
Will?
Oh yeah,
Will Fraser in
Fraser's
BC.
asking how we arrived at the $2,000 amount. Initially, back in 2001, as you all recall, our trust was, I think, $16.4 million, and out of that, the consensus was to pay everybody $1,000, with the exception of the old people. Old people I'm referring to as being 65 years and over. They received $2,000 moving forward. Now, with the amount of resources that are being, I guess, contemplated by the TLE offer of $30 million, it basically doubled our claim from 2001. So as a result, the rationale is just to increase it by that same amount. So $16.4 million turned into $1,000 per band member and $2,000 for old people. So twice the amount now, it's $2,000. So that's how we arrived at it. Simple math, basically, right?
You got that, Will? Just kidding, as he's listening, as he's watching at home. Then his third question was and I'd be more than happy to share this, these are not my questions, these are his. Was the comprehension of the $2,000 offer meant to sway votes? Honestly, one would feel leadership would invoke comprehensive efforts more towards translation of the legal documents as a fiduciary duty to membership than an enticement of a small one-time payout. What is your response?
Thank you, Anita. On behalf of your questions for Will Fraser, I apologize. Drawing. It's been a long day for me, so
Yeah.
repeat the question, please.
Sorry, he wants to know, was the comprehension of the $2,000?
Okay, was it? Well, yeah. No. There's no intent to try and coerce or make somebody, vote yes just because of the offer. As you remember, the trust back in the day, all beneficiaries, we're all beneficiaries. I'm not the chief, I'm a beneficiary. We all received $1,000 right across the board, right? So nothing different. There's no coercion, nothing like that. It's been 20 years since the beneficiaries received any compensation from the trust at all, any compensation. And yet, we still have to keep on going. We supported the trust tooth and nail throughout the 20 years. Now we're asking the membership to consider an amendment or that would give us the ability to look at the next 20 years in our community. And like I mentioned, probably for the majority of us, including myself, 20 years is a long haul. I'm hopeful that I'll be around 20 years' time. If not, it's going to be other people, other trustees that are leading our nation. So it's a progression that's always going to continue in life. And I appreciate all your concerns and questions to date, but at the end of the day, it's about the future of Mistawasis. It's not about the future of people now sitting around this table and what we can get and what we can get. I'm more focused on what's going to happen, when my grandchildren have that ability to reside in Mistawasis. I want them to have the same benefits as everybody across the board. So there's no tier systems. Nobody has no more benefits, more than X person members. When treaty was signed, the intent of the treaty was to try and treat everybody equally, right? Everybody received $5 a year in compensation, right? That's the benefits of treaty. And there's no way that this treaty land entitlement is here to take away your treaty rights. And that's another fallacy that's being pasted on Facebook. People are saying that we're going to lose our treaty rights if we support this process. That's not true. I don't think it is. But maybe you can ask the professionals, the legal people, if that's really true, a true comment. But that's the best I can answer those questions for. Nina?
Yeah.
Thank you.
And I want to thank you for clarifying that about our future generations, because I jumped on board this trust because of making sure that the land and the land dollars that are in these trust accounts are there, and there's something there for my grandchildren's grandchildren and everybody's generations to come. And I think that the concern is that the TLE, we could be voting on that right now, and with consultation and negotiating with the government, we could have agreed on a bigger payout than what we're doing now. I still don't understand this legacy trust, or where it even came from, and how we ended up that these two need to come together. I know you're going to feed me all of this stuff about it's better, it's cheaper, whatever it is, Stephen, but the reality is that when I looked up what a legacy trust was, the only definitions that kept coming out, it was like an estate planning for a will, and that you can put all of your assets into this, and it's protecting those assets from creditors or judgment from a court. And that started getting my wheels moving, like, what the hell is going on? So I got on this thing not to come up here and waste anybody's time. I mean, you're going to make your decision no matter what. I just want you to be told the truth and all the truths. And the reason I stand up here as a trustee and a member is that my very first day as a trustee, we met in Regina, and this whole thing was dumped on my lap. And I was like, well, it sounds wonderful. Yeah, I want to do this. And I said in my speech, I said to you guys, I said, I'll definitely support this as long as it's done correctly, and all of the, basically all the I's are dotted and all the T's are crossed. And as I learned more and more and more, that's why I come up here and I drill you guys, because there are a lot of changes, Stephen, lots. That specific agreement should have been included in this big, gigantic document. And this, people, is what the red line document is. These are changes from your specific agreement into this legislation. And that's all I wanted them to explain, all of those changes. Anyways, back in that specific claim agreement there in section 21, subsection 3, it talks about that the only way that this can be amended, really, is through sections 2101 and 2102. And 2102 is the First Nations Financial Management Act. When I read that, it kind of sounded like if the trustees were mismanaging the money, then we could do that. And the First Nations Management Act would step in. But we're not. We're 1.5 million over. And then the other one has to do with income tax and that. So I'm not too sure how this agreement you say anything can be amended, but really they can't. So.
In 2303.
Yep. 2103 and 2303. Because we talked about this, I don't have that section. Anyway, I'll read it later. Another one of his questions, Will Fraser's question now. When was equity payment defined for membership? What is the clarification? Please re-clarify now for membership. That's Will Fraser's question from BC.
Sorry, I missed that. Could you?
When was equity payment defined for membership?
That's a term that comes out of the settlement agreement. It's defined in the TLE settlement agreement. Equity payment?
So I think that what he's asking is, when was it defined for membership? Is it just now in this document? I guess is what he's asking.
It's a term of the settlement agreement that it's part of the term that Canada, that's part of that equity formula that David was talking about.
And then he said, to help membership understand, please expand on Article 3.03 of the TLE Settlement Agreement Overview and Summary, specifically the other purposes allowed for investment that are listed as sections but are not clearly defined for membership to consider.
Of the settlement agreement?
Yeah, to help membership understand, please expand on Article 3.03 of the TLE Settlement Agreement Overview and Summary, specifically the other purposes. It says the other purposes, but it's not really defined, is what he's saying. maybe while he looks for that, Chief, one question that keeps coming up to me is who is on the negotiating team?
The negotiating team comprises myself as the chief head negotiator. We've had Robert Daniels, Louis Ledoux, I think Stephen from council. I think 4 or 5 of us, right, Steve? Yeah.
Thank you.
And again, as being a part of chief negotiator, I have the responsibility to do initial documents, as you can see on all the trust and settlement agreements. That was my responsibility as chief negotiator to deal with that as part of the process.
Just quick response to the other purposes. If you look at that section that he quotes, it makes reference to all the sections that define or reference other purposes. That's in the settlement agreement. So.
Thank you, Stephen. And then we will be moving on to Louis to do his presentation. That case.
Thank you. Thank you, Roger. Good evening, elders, band members, chief and council. My name is Louis Tapper. I'm a chartered professional accountant, and I'm here to present information to provide my financial advisor's certificate. So what is being proposed is the amendment of the specific claim trust, the contribution of the entitlement monies of approximately $30 million. A new trust called the Legacy Trust will be set up and come out of the two items. Also, this will be recorded as a contribution from the First Nation, and that has positive income tax implication. The specific claim trust has approximately $14.6 million and 4,606 acres to contribute, and there'll be one trust. And 20 years ago, I helped the nation ratify the specific claim trust. We came to membership meetings. The members were very concerned that the trust property, the assets would be squandered, would be misappropriated, would be misspent. And I'm very happy and proud to say, come here to you and tell you today that over that 20 years, the specific claim has grown the trust property to $14.6 million, and they purchased over 12,000 acres of land. So of that, approximately 8,000 have been converted to reserve status. So the specific claim has done its job. Over that period of time, when we first started, everybody thought that investing was gambling. When you bought shares in Toronto Dominion Bank, people thought it was gambling, and so the new provisions are going to expand the investing powers and ability of the nation, of the trust. So what is my role? My role is to say, how is the safe custody of the trust property, the safe custody of the property, the preservation of capital? How do we make sure that the capital is going to be around as long as the sun shines, the grass grows, and the rivers flow? The management of the trust property. How is the trust property going to be managed? The investment of the trust property. How do we manage to do the investing? And disbursements and uses of the trust property. And we'll talk about financial issues. For example, some of the financial issues are rates of returns and risk, because rates of return and risk go hand in hand. And the other one is income taxes. We'll talk about income taxes as well. And just for clarity, in the 20 years that the specific claim has been around, it has not paid any income tax at all. Canadian income tax. So safe custody of the trust property. So the monies are going to be of the settlement and the specific claim trust will be deposited in a trust account at an institution. An institution is a duly incorporated entity that will carry on trust services in the province of Saskatchewan, and Royal Trust has been identified to be the institution. And Royal Trust is part of Royal Bank of Canada. The institution will only allow the transfer of funds in accordance with the trust agreement. They will follow the trust agreement. That's their duty. They are not a trustee, but they're an institution. They're a gatekeeper. They're there to make sure that the trust property is protected and the safe custody of it as well. And they do have the experience and skills. I've worked with Royal Trust, and they do their job. Preservation of capital. Once the monies are deposited into the trust account, they are no longer considered Indian monies. Canada has no more responsibility for them, and there are no protections under the Indian Act. So one area that could impact the preservation of capital is the investing, the authorized investments. Because if you invest in bad investments, you could lose your capital. However, what we've tried to do is develop, one of the requirements is they have to develop an investment policy with the help of an investment consultant. And with the investment consultants, the ones I've seen, sometimes the trust or First Nation says, well, what do we need an investment consultant for? What do we need them for? But when you hear them talk, you say, oh, wow, they are very smart and knowledgeable. So they can do their job. So the investment policy will determine the types of investments that a trust can purchase. And the investment consultant is very well educated and trained. They have to pass 3 exams, and their pass rate is 30%, so very difficult. So to get a chartered financial analyst designation, it takes a lot of hard work, and you have to be very, very smart. They're independent. They have to be independent of Mistawasis as well as the investment manager. For example, an investment consultant cannot sell investments. They cannot sell investments. The problem, so they're totally independent. And they have, like I said, lots of skills and qualifications. Before the investment policy has been developed, trustees can only invest in very safe, for example, bonds, certain bonds with very low risk, but unfortunately they provide a very low rate of return, very low interest rate these days. In fact, it's not even enough to cover inflation. So in real terms, you're losing money. So part one, very safe, secure investments until investment policy has been developed. And the investment consultant must assist the trustees with the selection of the investment manager and the institution. And they all have to have the necessary skills. The investment consultant must be retained to evaluate the performance. And this is really key because, for example, if you don't have the investment consultant, a lot of times the investment managers, they will evaluate themselves. So they'll say, well, we're doing a good job. Of course we're doing a good job. But an investment consultant will do the job for you. They're totally independent. They cannot be related to the investment managers. So that's one of the key roles. And generally speaking, for now, in the future, who knows what's going to happen in the future, but generally speaking, chief and counsel, the trustees aren't sophisticated enough with regards to investments to be able to monitor the investment managers. I'm a chartered accountant, and quite frankly, I can't do it. So, and I've been around this for many, many years. I've been to school. So that's the purpose of the investment consultant, is to help protect the members a little bit more and to protect chief and counsel as well. And there's a requirement to maintain $25 million, except in certain situations, for example, if you have to pay authorized expense, because the trust has to operate, or to not pay income taxes, because we never want to pay income taxes, because 47.5 to go to the government. I think as members, you'd rather have the money go to the nation to help support the members. So again, they allow for amendments in the trust agreement. That could impact the preservation of capital. You can amend it for taxation purposes, but if you're going to amend it, make significant amendments to the trust, you're going to have to do a vote. And members will have a vote. They'll do a similar process to like this. They'll come to you and they'll explain what amendments they are going to make, and they'll ask you for your vote. So the management, and I can't emphasize this enough, it's in accordance with the trust agreement, and sometimes I jokingly say it's like the Bible or the Ten Commandments. It says what you can do, it details what you can do. It's a legal document. The trust agreement is a legal document, so it does have teeth. If the trustees aren't following it, or the institution isn't following it, then there are legal remedies that you can follow. So it is a legal document. The trustees have to be selected by a selection committee. On the selection committee, there has to be some independent person. And right now, the independent person is a chartered professional accountant. He works for Peace Hills Trust, and I believe he helped with the selections of the last trustees. So that is an important step. It costs money to do it, to hire this person and the committee to help select the trustees, but it's a control, it's a mechanism to make sure you hire the brightest and the best possible people you can hire. And there's several articles that detail the duties of the trustees. And ideally, it picks the best possible trustees that you can pick. Management, again, Royal Trust will help you with the management. They're there to be a gatekeeper, to make sure things are done in accordance with the trust agreement. Council has a role, and that's Article 16. It spells out the duties of the council. For example, they have to be involved in the purchase of land, because that goes to reserve status and it will be the First Nation. So they need to be involved in that. To assist with reserve creation, they have to do the BCRs to go to Canada to ask them to convert it to reserve status. They work with the investment policy, they review financial statements, and they approve the operating budget. So they're kind of a gatekeeper for the trustees as well. They make sure that they don't spend money unreasonably. And I believe it's worked up to this point. There's good dialogue between the two trustees and chief of council. The other thing for management, and it helps with maybe the preservation of capital, is on an annual basis, you have to hire an auditor to come in and audit the financial statements. And the auditor has to be qualified to do audits. So the trust agreement really is designed to make sure you get the best people. And I'm sure all of us have heard our parents say, surround yourself with good people and good things will happen to you. So that's really the goal of the trust agreement, is to make sure you get good people to work with you. And it's designed for transparency and accountability. There has to be accountability. For example, with the money that chief and council get, they have to come to you on an annual basis and says, this is where we spent your money, because this is your money. Where did we spend it? The trustees have to come to you each year and give you an annual report. It gets published on a website. All this information is there for you as members to see, and you can demand it. That's your right. You can go and inspect their records as well. So it's designed to be transparent and accountable to you as members. And again, though there was 1,200 changes to the specific claim trust, the nuts and bolts are still basically the same. There's still the same agreement, and I have to say, since June 2001, it's worked. The trust agreement has worked. Could it have been better? Well, yes, everything can be better. Could it have been worse? Yes, it has, but the money is intact. The land has been purchased, so I would have to say, Capway, it's good. The other important thing is both are designed for prudent investor. It's important that it's a defined term in the Saskatchewan Trustees Act. It defines what a prudent investor does, and it has to evaluate risk and returns. And it's important to emphasize, and I'll talk more about it, that you want the best possible return you can possibly get with the lowest amount of risk. So the better, but generally, the higher the return, the higher your risks are. So prudent investor is an important concept, and it will help. Both trust agreement deals with preservation of capital and the safe custody of your assets, your property. So the main differences between the two, in my estimation, is you have to hire an investment consultant. And I think you'll find, and only time will tell, that the investment consultant is worth their weight in gold. And only time will tell. That's been my experience. I'm always impressed when I hear these guys talk. And they will assist you in selecting. They'll help you select the best possible investment managers that are out there. They will help you monitor those investment managers. They will compare to benchmarks. There's a benchmark called the S&P 500. So they'll compare it to that. How well did that benchmark? How did the investment managers do to that benchmark? Under the new Legacy Trust Agreement, the nation does not have to contribute funds back and to the trust to grow it. That's covered by the annual payment. There's an annual payment, and not all the income is paid out. It can be retained within the trust. And there's a cap on the authorized expenses under the new trust agreement. Again, some of the main differences are there's not a payment to members who are under 18. However, when they do turn 18, there is a payment out of the Legacy Trust Agreement. There's not a requirement to mail out information. However, they have to publish certain information on the website, and there is an annual meeting. And again, like I said, transparency and accountability. Chief and council has to report to you as members what they did with the money they get, the annual payment. On both trusts, revenue on the land that is purchased and rented goes into the trust account until its reserve status, and after its reserve status, any land lease revenue goes to the nation. And I'll show you a slide later on that kind of details that. And in both cases, the annual budget has to be approved by Chief and Council. So again, our investments, the investment in trust property, invest what a prudent investor would do, and we hire an investment consultant to help us with the investment policy, hiring and monitoring the investment manager. And that's an important step, a real important step. Distributions and use of trust property, this can erode the capital. For example, $5,142,500 will be paid to the nation, and $4.5 million will be used for a per capita payment to the members at least 18 years of age, and some money will be used to pay the First Nation for the expenses it has incurred. The remaining amount has to be spent in accordance with the Mistawasis financial laws and policies, and they have a financial administration law that details spending. It was not a law that they created solely on their self. It was part of the First Nations Management Board, and the First Nation Financial Authority required them to do this. It's a standard basically agreement, and that's covered in Articles 4 and 5 of the trust agreement. And then future distributions in the future 2000 can be paid to people who turn 18 years, and Chief and Council can increase that. Purchase of land, we're going to have to purchase land. Specific claim, 9,465 acres. The equity amount is 29,394, of which 4,352 is the shortfall. And the goal is to convert it all into reserve status, and that's Article 4 and 6 of the trust agreement. The investments, and again, we talked about this. I don't mean to belabor the point, but it's very important because the investing is very important. You have to follow the investment Schedule B until you develop an investment policy, but above all, the prudent investor. What would a prudent investor, what would, for example, me, how would I invest my money? Well, hopefully I'm a prudent investor. But there are, like I said, in the Saskatchewan Trustees Act, there's an actual provision in there that details what a prudent investor, and it looks at rates of return and risks and economic conditions, inflation, taxation, and various other items. And that's Articles 4 and 7 of the trust agreement. Annual payment, again, the purpose of the annual payment is one, to put some money in the First Nations so that they can do some land development, and again, it's administered by the financial, it has to be spent or utilized in accordance with the financial administration law. But what it's really designed for is to ensure we don't have to pay income tax because, and I'll talk more about this in a bit. And that's covered under Article 4 and 9 of the trust agreement. Authorized expenses, pay reasonable expenses, and to operate the trust, the trustees need to incur expenses. For example, they have to have meetings, they have to have an auditor, they have to hire an investment consultant and an investment manager. They cause you need to pay them. And your investment managers, they're discretionary managers, they're very, very good. And I always say they're the real Sonina Ogima. They are the money men. They will make money for you. And that's their role, is to make money. So you want the best people you possibly can to invest your money wisely. And again, there's a cap on the spending that the trustees can do. And that's Articles 4 and 10 of the trust agreement. Potential rates of risk and return, again, you've got to balance those two. And you don't want to take too much risk, but you want to have a good return. And I always use the Bank of Toronto-Dominion Bank. It's been around for many years, almost as long as treaties, in fact. But they generally pay, right now they're paying a 4% dividend, or thereabouts, a little less than 4%. And over the years, I would say they've returned 10% return, and I'm sure they'll be around as long as the sun shines, the grass grows, and the rivers flow, and I don't think the Canadian government would allow them to fail. So we have provisions in the trust agreement that will deal with risk and returns, like the investment policy, hiring the investment consultant, because they have a duty to you as members, because they have to protect you. That's one of their obligations, and that's why they're a chartered financial analyst. They have to be good. Same as me, I'm a chartered accountant, and I have duties and obligations that I have to follow. So what does investment policy? It addresses matters as performance goals. Like I said, benchmarks. They compare them to what benchmarks they are operating under. And risk tolerance, they will assess what risks you're willing to take. And again, I can't emphasize this enough, but the investment consultant has to be independent. And independence is important. important for Stephen, it's important for me, it's important for David to maintain our independence. So they can't sell investments, because if they could sell investments, they would probably say, well, hire me, because I'm the best. But we don't want that. We want them to pick people who are independent. And again, his job, the investment consultant, is to assist and make the trustees better at what they do. And every 3 years, they have to do an evaluation of the investment manager. George and Bell Consulting, they're from Vancouver. They do lots of First Nations trusts, and it seems every day they take on a new trust, because what they do is help make you money. And they do cost money, though. They don't come cheap. But sometimes when you hire people, good people, you have to pay them. And again, the actual return and risk will depend on the investment policy, and that's a key document. The world economy and who has control over the world economy, and the skill of the investment managers. And that's why you want to hire the best investment managers. Income taxes, everybody's favorite. And again, contrary to what people say, First Nations or their organizations, they do have to pay income tax. So what we try to do is take sections out of the Canadian Income Tax Act that will help ensure you do not pay tax. So it's very important, some of the rules. And we'll talk more about what the rules are. You will have to pay foreign tax, but you can hire a lawyer. He's from Vancouver as well, and he will do an election for you that says you do not have to pay withholding tax. For example, if you own shares in Apple and they pay a dividend, if you don't file the elections, there's a 15% withholding tax. So you can file an election and then that won't be deducted from you. The trust should not be, the way we've got it set up, it should not be subject to taxation in accordance with the Income Tax Act, as well as there's provisions in the trust agreement that you can change it to make sure you don't pay income tax. There's the 21-year rule that says every 21 years there's going to be a deemed disposition. So the trust agreement is designed so you can get yourself around that. But this trust agreement's not going to have 21 years because it's going to be, everything is going to be sold shortly. The trust, for legal purposes, a trust is not a separate legal entity. Trust is giving assets, so the First Nation is the settlor. It's going to give assets. It's going to be managed by trustees, and the First Nation is the beneficiary. And those are important concepts for taxation purposes. So for tax purposes, and this is tax purposes, not legal purposes, Canada Revenue Agency sees a trust as a separate individual. An individual, it's not a corporation or a First Nation, it's an individual, and it's taxed at the highest tax rate, which is 47.5, and you have to file a T3 information return. In the past, the trustees have not filed a T3, but I think they're going to start now, and that's my recommendation. So, taxation, to not pay income tax, we use two basic provisions. One involves attributing the income to the settlor. That's why I said the First Nation being the settlor is important. We're going to allocate that income automatically. Gets allocated to the First Nation. And two, to make a payment to the First Nation or the beneficiary. And you're going to sit there and you're saying, well, does a First Nation have to pay tax? Just bear with me and I'll get to that shortly. So there's the attribution rules is 75.2, which says automatically it's attributed back to the settlor. Where this came in years ago, my colleagues who deal with rich people were setting up trusts. So the rich person would contribute money to a trust, and the income would be allocated out to his minor children. Well, the minor children didn't have any income, so the income was taxed in the child's hands, and they were taxed at a very low tax rate. So Canada Revenue Agency says, wait a minute, that's not fair. We're going to change the rules. We're going to put 75.2 in, which attributes back the income back to the settler, the rich person. So he has to pay tax at the high rate. All my colleagues were crying, and they're saying, all this hard work we did was for nothing. Now they changed the rules and they were going to pay tax on it. But Louis was saying, yes, this is perfect for my First Nations and trust, so that we can attribute the income to the First Nations. And again, I'm going to tell you why the First Nations not taxable in a bit. So that's on the original contribution. If you earn income on that income that you've earned on the original settlement, the original funds, then you could have to pay income tax. So 75.2 will only take you so far. That's why we use 104.6. We make an annual payment to the First Nations so that the trust doesn't have to pay 47.5% in taxes. So the Tax Act is very good to the First Nations so far. So Mistawasis is exempt from income tax under 149(1)(c) of the Income Tax Act because it's a public body performing a function of government. And when we deal with Canada Revenue Agency and taxation, we work under the Income Tax Act. We don't talk, unless we have to, Indian Act. We don't talk treaties. I'm not in a position to talk treaties. We would have to get an elder involved in talking about treaties. So we try to deal, if we had to play that card, we would, but generally speaking, I don't think we have to because we're covered under the Indian Act. In there, we do, under the old rules, it talked about first about it being a municipality. A lot of the First Nations I work for do not want to be called a municipality. From my understanding, a municipality, and why they don't want to be called referred to a municipality, is because a municipality is subordinate to the province, and the province is subordinate to Canada. And First Nations say, we are a nation, and we're going to negotiate with Canada nation to nation. So they don't like the term municipality. So in summary, hallelujah, we don't think we have any income tax to payable in the trust because of 75.2 and 104.6 of the Income Tax Act, and the Mistawasis First Nation is exempt under 149(1)(c), a public body performing a function of government. And also, there's places in the trust agreement that says we can amend the trust agreement or we can make additional payments to the First Nation to make sure we don't have to pay income tax, because we do not want to pay income tax. So, a summary here. In 25 years, and we got the various interest rates, and I don't know why some of the information dropped off here, but the bottom line is if we return 1% back to the trust, 1.5%, which is, I'll do a chart in a bit that will give you the detail, and you will have $58 million at the end of 25 years. So your $40 million will grow if we return 1.5 back to the trust, or remains in the trust. 50 years at 1.5%, it will be $84 million. How did we get to some of those numbers? So if you look at the chart, you'll see the deposit of $40 million. We're going to assume a 7% rate of return. It's an assumption based on my understanding of discussions with the investment consultant. They think they can do that with a reasonable amount of risk. And that's on the average. It might be 5% one year, it could be 10% one year. We don't know. If I had a crystal ball, I probably wouldn't be here. I'd be sitting on some beach in wherever. Authorized expenses, we said we're going to cap it at 1.5. Payment to the First Nation is 2%. So the agreement says until all the land has been purchased and reserve status, only 2% can be paid to the nation. After that, 4% can be paid. Inflation, we're assuming it's 1.5. when we did this, 1.5 was a reasonable amount. Right now, inflation is 3%. So we said 1.5% on the average. So all we can do is plug numbers into here and see where it goes. The land purchases, $1,000 per acre. I know it says per year, but it's acre. Increase in price annually, 5%, so we expect the land to increase 5% a year. Lease revenue is $50 an acre after taxes. And once it's in reserve status, it's not the trust anymore. And on the average, there's going to be 4,000 acres in fee simple, which is non-reserve. And inflation is 1.5. So looking at the hard numbers, you can see that, sorry, and I'm going to move away. Over 25 years, there's going to be almost $24 million paid to the First Nations. So what are they going to do with that? Well, it's governed by the financial administration law. Hopefully, they will do education, social development, hopefully some economic development. It'll make the community better, God willing. So inflation, what you're going to return to the trust to make it grow is $18 million. So you started off with $40 million, and you're going to end up with 58. Funds available to purchase land, and again, that we made an assumption. If they decide they found a great piece of land and they had to buy it, the purchase might be bigger, and as a result, the capital or the trust property won't be as high. So over that period of time, that $30 million, they're going to be able to buy 17,000 acres. Please remember the 4,600, and Stephen pointed this out to me, the 4,600 acres, that 4,606 acres is not in that amount, so really it's 21. And don't forget about the 8,000 acres or so that's put in reserve status already. So in that number, once it's reserve status, the land goes to Chief and Council. They will collect the rent. They will generate $50 an acre or so on that land, back more because they don't have to pay taxes anymore. What are they going to do with that money? Well, that's not in the 24 million I talked about earlier. So that's an added bonus to the First Nation. They can use it for economic development, social development, but it will be governed by the financial administration law. And every year, Chief and Council has to do an audit on their consolidated financial statements. So like I said, there's accountability and transparency. They have to tell you what's going on. So this could be significant and to the future of your nation. And again, these are some of our assumptions. And again, that expression's assumption, you know, it kind of, all they are is assumptions, they're guesses, they're our best guess. And so what do they say about assume? It makes, an ass out of you and me. So that's why I don't like assumptions and coming up here and saying, okay, these are what we think is going to be in the future, because who knows what the future is going to bring. All I know is if we do things right, it'll be all good. And that's the end of my presentation. I'm glad to take questions. I have to be available to answer questions down the road. If you need my phone number or email, contact Roger or the band office. They will let you know how to get a hold of me. But I gladly answer any questions as best I can. Excuse me, I'm going to get a drink of water.
As for me, I like the idea of amalgamating them, because that'll save a lot of money. But I'm kind of confused on that settler on that, the lettering, the spelling.
Yeah, OR. It's not the settlers who come over from Europe. It's not those settlers. It's a settler is a legal term with regards to trust law, as I understand.
Okay, I was just wondering what that meant.
Oh, you couldn't hear me? Oh, sorry. The settler, it's with an O. It's a legal term with regards to trust law. It's not the settlers that came over from Europe. It's a different settler. It's an O. Okay. On that note, thank you, everybody. I wish you all the very, very, very best. And we'll see you in a couple weeks, because we'll be back doing another presentation. So if you come up with some questions, we'll gladly answer them here. Eiko se. Ketama.
Thank you, Louis. So I have one question from band member. I have a question from a band member online, and I think it's for you, Stephen. I'm not sure. It's from Patricia Ledoux. That why is land, in quotation marks, to be purchased and made back into reserve status?
As I mentioned before, there wasn't a commitment under the treaty for Canada to provide land to fulfill an outstanding treaty land entitlement obligation. And then Canada had to acquire this land from the province, because under the Natural Resources Transfer Agreement, the province was supposed to provide the land so that Canada could provide that as part of the treaty land entitlement. As I mentioned, this bogged down over third-party issues and all that. So what happened was the Assembly of Entitlement Chiefs reached an agreement that instead of, because Canada and the province were unable to transfer actual land, then they would agree to provide enough financial resources so that the First Nation could go out and acquire that land, and then Canada would transfer it to reserve status. So that's why there is the financial resources provided under the settlement agreement, the $30 million to at least get that shortfall acres, and then you can use any balance of that money or future interest earned or revenues earned on that to acquire up to the equity acres. Okay?
Okay, thank you, Dave. What is the, okay, so we're streaming on YouTube. How do band members go and look at that? Use a mic, please.
Thank you. Thanks. After the video is done streaming, it will automatically upload itself to YouTube. So you can go and search for the name of the stream. I believe this one is Mistawasis TLE presentation, October 15th. I'm also going to be downloading the videos and putting them onto the thumb drive, sending them to the First Nation so that they can upload it to maybe their YouTube channel or to the website or what have you, but I'll do my best to help distribute it.
All right, thank you, James. So with that, are there...
Just a question. I know there's an opportunity on YouTube live feed to make some questions, and I'm not too sure if any came through through the presentation. I can't see it, but are you able to make any comment regarding if anyone made any comments on the YouTube live feed?
Sorry. I believe 2 of our previous streams we had questions pop up, but I haven't seen any during this one.
And the one that I asked was the only one that my wife... Oh, that was on Facebook. Yeah, absolutely. Yeah, if any of the band members have questions that they want to ask, yes, they can send to landclaims@live.ca. We'll be watching the. I encourage everyone to watch the videos and encourage any other band members to watch them. And any questions, you can talk to, Stephen put his contact information up there. You can also contact Louis, and if I can be of service, then you can contact me at the Land Claims office. Oh, and also you can contact Debbie Watson at the band office. Contact her first before you call me.
First of all, I'd like to thank Roger. I'd like to thank Stephen, Louis, and Dave. And Debbie and all the people that helped put these 3 days. It was a long 3 days. It was a lot of work. Thank you so much. I just like to encourage everybody out there to help get your families to vote. Like the chief said, it's either yes or no. But we all had an opportunity to listen today, which was very good. The question I had a concern in PA. My granddaughter came there, and she voted, and she sealed it, but she didn't have a witness. So those are some of the things you're going to run into. But I talked to Debbie, and it could be looked after. So make sure you get a witness to sign your, your vote. Thank you once again.
I just like to, Mike, just kidding. I just like to thank all the past negotiators that have left to the spirit world. I'd like to thank all those negotiators, and I'd like to thank the present negotiators, lawyers, and Louis. I'd like to thank Chief and Council and members for all the work they did in negotiating for us.
Thank you very much. Any other questions, comments? Colby?
Well, I guess now that all the interesting part of the night is done, I just want to say, coming from a person in my generation, I know that things on the reserve, a lot of stuff like this can get muddied in the water. I truly do believe, speaking from our leadership table, that a young person who has went to school and has at least taken the time to learn this at somewhat of a level. It's what people do. These concepts are not new in the outside world, but they're very new in Indian country. And I understand that it's a very fearful thing, and I get it. But we would not be feeding you this information if we did not believe that it solidified a future for kids that I don't even have planned yet, and hopefully their grandkids. And like I said, it's either a yes or a no. But from the bottom of my heart, I truly believe that for our nation, for the logo, for everything that this community is, for our former chiefs, all the former councillors, William coming with some great questions, that's what this is about, for people to come and ask and seek the truth. And I want to thank everybody from the community for being a part of this in the last 3 days. It has been long, but we will be back here again in a couple weeks, and if you guys have more questions, please come. I highly encourage it. I just want to thank everybody for being a part of this process, because it really is a privilege. And just one other thing personally, our community owes Mr. Lawrence Johnstone an immense amount of gratitude for ever getting to this point, because without the research and the hard work that gentleman has done, that I have learned just in my short time being in office, that he deserves a lot of credit that if this goes through, because without that man, this would never even be a thing for our community. It's not very often that $40 million just presents itself. And with that being said, thank you everybody for coming out. Thank you, Lawrence. Thank you, legal counsel. Everybody have a great weekend. Stay safe and drive safe. Thank you.
Thank you. So we will be doing this again, like Colby said, in a couple of weeks. November 3rd in Saskatoon, November 4th, Prince Albert, and November 5th back here again. Oh yes, there will be the next round of meetings. There will be door prizes for anyone who attends and has to stay right to the bitter end. Any other comments? So with that, Elder Mistawasis, please say the closing prayer.